Welcome to Skyye Lyfe, everybody. Woo! I had to make it back. They dropped the motion for Kales, and tonight we will be going over it. It's a couple of things that came out, but today we're just going to go over the motion for let's see. Oh crap. I hate that you got to go to a whole nother page to scroll to the thing. We're going to go over the motion for a new trial. But welcome everybody to Skyye Lyfe. Thank you for coming back. If you have not subscribed, please hit the subscribe button and hit the bell. That makes sure that you get the notifications once I go live. Also, make sure that you hit the like button, okay? We're going to start once we get to 10 likes, and then we're going to go ahead and go forward. Hey, Miss Lady T and K, baby. What's going on? I'm glad y'all back. I'm glad you all are here. Y'all, I'm so excited. You know, I haven't read the other motion, but I really, truly believe that Miss Bonjean has done a great job in her writings, you know, of the motions. And I really, truly feel the Kales is going to come home. Okay. Now, based on what I received, well, let me give people a few minutes to come in here and then we'll keep going. But everybody, please hit the like button in the meantime. And I'm going to give a few people a few moments to come in. And let me see how the channel looks. I got to start going over. Okay, your channel. Ooh, Kels is so fine. Kels is so fine, y'all. Okay, it looks like it's okay. Hey, Elvira. Welcome back to Skyye Lyfe. We glad to see you here. Look, are you excited about the motions? That's right, Miss Lady T. They big mad. Oh, they are big mad. They big mambo jumbo mad. I'm telling you. Because you know what? Yes. Be excited, you guys, because it is, to me, a well-written document. Well-written. Okay? She said, I think she has two based on what I've heard. I'm going to read it all tonight. Probably won't get. I swear, the doggone thing is 50-something hours, and then Dana just said that that once you start reading it, you're not going to stop. So, you know, I'm just like, come on. Uh-oh, you said some heads gonna roll? Oh, Lord. Tori, what's going on, girl? Yes, we the late nighters. We the late nighters. Now, wait a minute, because after I read, and I'm going to try and do it swiftly. Hopefully, I don't get the dry mouth. And then we're going to have a little panel. Hopefully, we don't put everybody to sleep, but we'll have a little panel. And then we'll go from there. Oh, yeah, but they big mad, you guys, because everything that almost every blogger has said in regards to ineffective counsel, in regards to the jurors being tainted, everything that we've said. I was just over on Angie's channel, and she was reading something about the herpes, them challenging the intent for Kales giving them herpes, and then she filed some other motion asking for an extension So they thinking that she's gonna file more motions on Kel's behalf. So I mean, this is my thing, and I feel like it's a checkmate because she filed a motion for a retrial and she filed a motion for an acquittal. Okay, now if that ain't a checkmate, then I don't know what is. Because this is my thing. Now, if both of those get denied, we already know what we dealing with. But guess what? To my understanding, and Miss Elvira, our legal Smeagol, let me know if does that then go to an appeal? Because I even said yesterday that the judge that some of the rulings that the judge made in regards to not impeaching those witnesses was wrong. So we gonna have to be up. We gonna have to read the other motion, and then we gonna have to get it in. Maybe tomorrow, Saturday and Sunday. This is gonna be the new topic anyway. Y'all know everybody gonna be talking about it. So tap it in for the new motion T. I understand we got us a pit bull in the skirt. Oh yes, yes we do. And she is not playing. She is not playing. And the one I'm reading, Tori, is only like 22 pages. Okay. She done also put one in. Let me see. Can I pull that up? Hold on. I don't want to mess it up. I ain't gonna mess it up. Once I put that one down, then I bring the other one up. I don't want to not be able to get back to that one. But she put in one for 77 pages. Hey, Queen Diva. Everybody, welcome to the chat. Do I got some mods in here? Mods, it is very important that you all say hello and welcome everybody to the chat. Also say goodbye when they leave because I'm going to be reading. So I'm not going to see what's going on. So if you could please do that for me, I would appreciate it. And also, if any bugs come up in here, I need y'all to ignore them and press on. You see what I'm saying? Don't even deal with them. Ignore them and press on. Let's see. I don't have no mods in here. What had happened? Hold up. Wait a minute. I don't know what happened. Okay, there go A Peasy. Okay. A Peasy. It looks like right now you the only mod that we have. So if you could please welcome people and also say, goodbye to them if they say that they're leaving, because I'm going to be reading, so I'm not going to be able to see what's going on. Bruh, make sure nobody cussing in the chat. Okay, we're going to try and be civilized. All right, y'all, so we about to get into it. Everybody please hit the like button. I need us to get them likes up to at least how many people we got? 9 people in here. I need to see at least seven likes or something. So let's do a motion of silence for them likes. Especially if y'all about to have me reading all this stuff. I mean, my Lord. Queen D, you said we've been hearing with the transcripts. That's right. Rule 29 and what's the Rule 33, Queen Diva? What is that? Yes, the case was tainted from the attorneys on down to the parents. Yes, absolutely. Okay, motion 33, she didn't get to visit with him due to the MDC. Oh, okay. That's what Greenberg was saying. Didn't do either. It goes to the Second Circuit. Okay. If they can't, okay. If she denies both of these motions, you're saying, Queen Diva, that it goes to the Second Circuit. and she ain't done, we going to the Supreme Court. I think if we have to, we're gonna have to go. Appeal it will be. Judge would be smart to grant one of these motions. Hopefully when hopefully he coming home. Yes. How do you not grant one of these? We have a motion for a new trial and we have a motion for an acquittal. To me, that's checkmate. You see what I'm saying? To me, that's checkmate. So for you to, if you come through and deny both of these motions, I'm looking at you sideways, because she clearly quotes in here which constitutional rights of his have been violated. That's right. We're going all the way to the top nonstop. That's right, if need be. That's the retrial, 22 pages. Yep, that's the one I'm going to read. She not playing no games. I'm going to need her to add Greenberg and Anton. They shouldn't be absolved. So wait, Queen Diva, you must have already read the y'all. Queen Diva read all the pages. She cheated. She's ahead of us. She said, I think those people are in shock. Yeah, they in shock. They are in shock because you got to understand. Hey, Peasy, Queen Diva, we have been, Kel's supporters been getting kicked down because all the motions that were submitted before got denied. So our hopes will go up and our hopes will go down, you know? And it just, and even though I think some of the stuff was well written by Koenig, they still denied it. You know, so we've been through it. Say she is not in only for real. Yeah, it's crazy. Baby, then other people going, yeah, they upset. They already upset, Tori. I was just over there and they trying to rationalize and act like what the paperwork that they always want to talk about. The paperwork ain't right. No. The paperwork. You know, it might be a couple typos, you know, but you know, just like they had some typos in the transcripts. I was to hear all the things as mom did and said, now that's it, Elvira, you cheated too. They ahead of us, y'all. They ahead of us. They done read they read this already. They read the good stuff. Oh my God. Hey, Peasy, can you block that bot? I don't even know what that right there. Whoever that is, block them. Oh yeah, absolutely. And cuss words, APs. No cussing. We're holy today. We're holy. Okay, y'all. So we about to start reading. Look, we about to start reading like y'all gonna read with me. Ooh, Father, help me. Okay, I'm gonna be on the other page, you guys. So I can't see if any other people come up in here. Get them out of here. Okay. We're going to might have some new people coming here. Y'all, please welcome them. All right, I'm going over. So we at the top. I hope y'all can see it. United States District Court. Hold on. Do I got my... I hope you guys can hear me. I got my mic close to me now. Okay, United States District Court, Eastern District of New York. Okay. United States of America versus Robert Sylvester Kelly, also known as R. Kelly defendant. We are reading a notice of motion. This is the defendant, Robert Kelly's memorandum of law in support of his motion for a new trial. Wrote by Jennifer Bonjohn Law Group, PLLC. Okay, that's the address. Attorney for Robert Kelly. All right, they have the table of contents on here. The argument one is defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful Buyer Dyer, Boyer Dyer, oh Lord, Father, Boyer Dyer of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory documentary Surviving R. Kelly and were familiar with prior accusations of sexual abuse of minors against the defendant. I added counsel's objectively unreasonable. Well, no. Counsel's objectively unreasonable performance during Buyer Dyer resulted in the impaneling of a jury that was neither fair nor impartial. I'm coming back over here. Where my legal smeagles at? What is Buyer Dyer? What is that? Queen and Elvira. What is that? Queen, I thought the 30 motion was to finish breaking down all the other violations. She didn't get to finish up with Kelly due to the lockdown. Can y'all tell me what the Buyer Dyer, what is this word right here? What is that? Do I got to Google it? Because I know I done merged that word up. All right, you guys, I'm going back over. We're going to have to Boy dear. Okay, what does that mean, Queen Diva? Hey, 312. I'm about to be on the other side reading. Boy dear. Okay, well, I'm about to go back over there, y'all, so I can't see the panel. APZ gonna hold it down. Hold on, let me yeah, I merged that word up. Okay, 2, defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government's star witness, Jane, that was imputed to the entire defense team. Oh, let's read that again, long and short. Basically, she's saying the attorneys failed. Basically, ineffective counsel right here. Okay, and they saying that the jurors were tainted because they watched the documentary and that they also were familiar with prior accusations of sexual abuse of minors against Kels. And they're saying the counsel's objectively unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial. Okay. And then they're saying right here, there was a conflict of interest with one of Kel's trial's attorneys with the government star witness. Y'all, who was the star witness? I'm going to come back. Who was the star witness, y'all? And put it in the chat. Who was the star witness? Can y'all hear me? Can y'all hear me? Okay, there we go. That's right, Elvira. All right, I'm going back over. I want some participation from the look, I want some participation from the chat. All right, I'm going back over. Okay, table of authorities. This looks like the case law. I'm not sure. Okay. I'm going to go slow so you all can look at this. Okay. And then we get to the introduction. Lord, they're going to have me get the Google. It is axiomatic that a defendant is entitled to the effective assistance of counsel. Jesus. Lord have mercy. I don't even know what that word means. And Skyye Lyfe thinks she's smart, y'all, but I don't know what that word means. Hold on. I got to go to Google. Where you at, Google? Google, what does axiomatic mean? Uh-oh, I don't have it up. Doggone it. Self-evident or unquestionable. Okay, that's a definition of axiomatic, you guys. To be self-evident or unquestionable. It is axiomatic that dividends have to be financed. Okay, let's go. We learned a new word. In the first sentence, she's saying ineffective counsel right there. It is axiomatic that a defendant is entitled to an effective assistance of counsel. U.S. Constitution Amendment 7 incorporated in Defendant's Sixth Amendment guarantee is the right to conflict-free counsel. Defendant was denied his Sixth Amendment guarantees in a number of ways, some of which are clear from the record, some of which are not. In this complex RICO prosecution, defendant's legal team fell apart mere weeks before the commencement of trial. The docket reflects that defendant's lawyers were unable to effectively represent defendant as a team. Energy, resources, and time that should have been devoted to preparing for trial were expended battling each other until two of the defendant's more experienced attorneys were granted leave to withdraw. Defendant was left with a disjointed, unprepared trial team and no singular defense strategy. Woo-wee! Let's go. This motion identifies two serious violations of the defendant's Sixth Amendment constitutional guarantees that require a new trial and are apparent from the record. Specifically, defendant is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced, to the seating of jurors and were jurors who were unqualified to serve on this jury. Okay, so y'all, I don't know what they trying to do, but I'm a little hood, so pronouncing these words is a little funny, y'all. Let's do that again. Okay. Defendant is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on this jury. Defendant was also denied conflict-free counsel, where his attorney, Ms. Becker, simultaneously represented one of the government's key witnesses. These violations of defendant's Sixth Amendment rights are so serious as to demand a new trial without showing of prejudice. Woo! Let's go. What is that saying? Contemporaneous. Woo, Lord. They bringing the words out, y'all. With this motion, defendant is also filing a motion to leave to supplement this motion where undersigned counsel may raise additional claims. Oh, let's read that. Contemporaneous with this motion, defendant is also filing a motion for leave to supplement this motion where undersigned counsel may raise additional claims of ineffective assistance of counsel, some of which may depend on outside the record information. Okay. Now, legal smeagles, I need y'all to take note of that because I want to talk about that. I need that clarified. I got my notepad. I want to talk about contemporaneous motion for leave. Okay, let's go to the next page. We don't want to be out here all night. Legal standard. Federal Rule of Criminal Procedure 33 provides that upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. Unlike Rule 29 and Rule 33, confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. But such discretion should be exercised sparingly. Okay, they cite case law. So they're basically saying that if the defendant's motion, the court, okay, wait. If the rule provides the court may vacate any judgment and grant a new trial in the interest of justice. Okay, so basically, if there's a violation of his justice, he could be granted a new trial. That's long story short. The argument is this. Defendant was denied effective assistance of counsel where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the Okay, I'm going to read what it says, y'all. I'm not going to be cute. Okay, some of whom watched the inflammatory docuseries Surviving R. Kelly and were familiar with prior accusations of sexual abuse of minors against the defendant. Counsel's objectively unreasonable performance during voir dire resulted in an impaneling of a jury that was neither fair nor impartial. Let's read it again. Counsel's objectively unreasonable performance during voir dire resulted in impaneling of a jury that was neither fair nor impartial. Okay? You all know how we sat up and said multiple times that the jury was tainted and that we knew something was wrong with the jury, but since the jury was sequestered, we didn't have any information on the jury. We saw the questions, but that was about it. We didn't get any fine details on that. So here we go. They're letting us know we were correct. Okay. As United States Supreme Court Justice Black stated, they're citing case law again. It is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudiced the case. That is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Oh, I got to dry mouth. Lord, y'all. Okay, let's read that again. It is difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case. That is because due process means a jury capable and willing to decide the case solely of the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. The United States Supreme Court observed the right to a jury trial guarantees to the criminal accused a fair trial by a panel of impartial and indifferent jurors. This is true regardless of the heinousness of the crime charged. The apparent guilty of the offender. Okay, that's what it says. The apparent guilty of the offender or the station in life which he occupied. A juror who has informed an opinion cannot be impartial. Okay. Rule 24 of the Federal Rules of Criminal Procedure governs voir dire in criminal trials. The rule provides that if the court examines jurors, it must permit the attorney for the parties to A, ask further questions that the court considers proper, B, submit further question that the court may ask if it considers them proper. 24A, a trial judge who under Rule 24 decides to examine prospective jurors himself must at the very least solicit questions from both parties' attorney. Okay, that's citing case law again. Naturally, the trial court's duty to ensure that each and every juror is fair and impartial is heightened, whereas here, pretrial publicity has greatly increased the odds that a potential juror has preconceived views of the accused's guilt. Case law. In this case of substantial pretrial publicity, jurors' subjective assessments of their own impartiality may not adequately screen for the possibility of prejudice. In an effort to protect defendants' cherished guarantee of a fair and impartial jury trial, the court implemented a procedure whereby potential jurors were asked to complete questionnaires that probed whether they had prior knowledge, preconceived notions, or biases about defendant given the unprecedented pretrial publicity he faced. Indeed, the questionnaire contained an entire section entitled Knowledge of the Case and People that asked jurors to reveal whether they had read, seen, or heard anything about the case, the alleged crimes or people involved, and to describe in detail any information they had previously learned by the defendant. The questionnaire expressly asked prospective jurors whether they had watched or heard any interviews of Robert Kelly, of any TV shows featuring him, or any specials or documentaries about him. Oh my God, we only on page 3. The court invited counsel for the government and the defendant to review the questionnaires in advance of jury selection and determine whether they could agree that certain individuals should be excluded for cause. The parties conducted that process and identified a set of potential jurors for the voir dire process. Inexplicably, Lord have mercy. Inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on the defendant's jury, who were clearly unqualified to serve on account of their preconceived beliefs of the defendant's guilt. Okay, right there. She's stating that based on the questionnaire and the responses, they already deemed Kells guilty, so he didn't even have a shot at a fair trial. That's what she's saying. These decisions cannot be justified by trial strategy, where the record fails to reflect that trial counsel conducted a sufficient inquiry to the probe of jurors' biases. Indeed, trial counsel was mostly silent throughout voir dire. Although the court was responsible for questioning prospective jurors, it afforded the parties the opportunity to weigh in the questioning of the prospective jurors who had made representations in their questionnaire that raised red flags. These questionnaires were highly effective tools for putting the parties on notice of jurors who might not be qualified to serve, but trial counsel made no effort to drill down on troubling representations that demanded further inquiry to ensure that the jury could be fair and impartial, regardless of any assurances he or she provided to follow the court's instructions. Perhaps most troubling, most defendants' jurors were aware of prior allegations of sexual abuse against him, and several seated jurors had actually seen a scathing, one-sided docuseries entitled Surviving R. Kelly. And several seated jurors had actually seen a scathing, one-sided docuseries entitled Surviving R. Kelly. And several seated jurors had actually seen a scathing, one-sided docuseries entitled Surviving R. Kelly that portrayed defendant as a serial predator and included interviews with many of the government's witnesses, albeit outside the adversarial process. I wonder why there's a problem with them seeing Surviving R. Kelly. Maybe because it was a docuseries that was not factual and wasn't true. We'll continue. Defendant's jury should not have included a single person who saw the documentary Surviving R. Kelly. It defies all logic that a juror could possibly remain indifferent and consider only the evidence heard from the witness stand after watching this docuseries. Go, Bonjean. Let's go. She said it defies all logic that a juror could possibly remain indifferent and consider only the evidence heard from the witness stand after watching this docuseries. That's right. After you watch that, you are 100% tainted. Pitiful. We'll continue. Wait a minute. Let's see what this said. Something about Rolling Stones. Okay. But this court could not make calls challenging, could make challenges for defendant or defense do defense counsel's job for it. Oh, let me read that again. But this court could not make calls. I don't like how they word stuff. Could not make calls challenges for defendant or do defense counsel's job for it, although it tried at points. Ooh, she just got down on them right there. It was defense counsel's responsibility to conduct a meaningful voir dire, particularly in this highly publicized case, to ensure the defendant's jury was fair and impartial. Trial counsel failed in this duty. Woo! For example, let's get into it. Jury number 3 provided the following information in the questionnaire. Question 29. The case for which you are summoned involved the defendant, Robert Sylvester Kelly, also known as R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, or people involved? Their answer was, I watched the documentary, but I forgot the name of it. 30. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Yes. The answer was yes, entertainer. I heard that he has been sleeping with underage girls. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any specials or documentaries about him? Her answer was yes. What were your general impressions? I saw the documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. Question 91. Do you know anything about the Me Too movement? Yes, it's a movement that seeks justice for rape victims 25 to 30 years after the fact. Oh, Father Jesus, if y'all could see my face right now. You see what I'm saying? People have their own understanding of things, and this is actually a juror only case. The question again, 91, was do you know anything about the Me Too movement And she said, yes, it's a movement that seeks justice for rape victims 25 to 30 years after the fact. Let me check on y'all. Ooh, Lord. Hey, y'all. Is everything going okay? I'll have to check on y'all. Has everybody been welcome to the channel? Hold on, Nisimo. I'm going to give you. Hold up. Hey, Peasy, have you been welcoming the people? Trials and tribulations, how you doing? Chi-Town, what's going on? Hold on now. I need you to. Okay, good job. There you go. Just join. Okay, good job, APZ. Good job. Good job. Okay. And Nisimo, you said you're going to mind for me too. Please make sure you welcome people to the chat. And say goodbye to them when they leave. Make sure nobody cusses. I appreciate you guys. Everybody doing okay? You all hearing this BS that they talking about? Surviving the lies. That's right. That's right. He will be home. Y'all good? All right, let me keep on reading because we want to try and be able to do a little panel. All right, thanks for coming, Trials and Tribulations. Okay, give me a moment silent for the likes now. Where we at with the likes, y'all? Hold on, let me go look. I hope y'all ain't playing me with these likes. I'm about to go look right now. Woo, we got 14. All right, y'all. Let's get them up to 20. Let's get them up there. Because whenever you hit the like button, it helps share my channel with people. Okay, I'm going back over there, y'all. I'm going back in. But do y'all hear these jurors? These jurors, these are the jurors that Kels had, y'all. They was already biased. He was already convicted before the... I have been saying that documentary series killed him in the beginning. I've been saying that. Okay. And it just feels so good to see that a legal Smeagol agrees with me. But I'm not the only person that said it. Other bloggers have said it too, but I'm not a blogger. But other people have said it too. You see what I'm saying? And it's just good to see that she's agreeing with the stuff that, that we say. Okay, I'm going back over, you guys. All right. Trial counsel did not ask the court to question the jury further about his responses to these questions or determine whether the juror could truly serve as impartial and unbiased juror in light having seen the salacious and highly prejudicial documentary series. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about defendant's prior legal issues or his reputation for sleeping with underage girls. Frankly, anyone who had the documentary series should have been automatically removed for cause. Let's read that again. Frankly, anyone who had seen the documentary series should have been automatically removed for cause. Juror number 4 revealed in questionnaire. Ooh, she going down to jurors. That was juror number 3. Now we finna break down juror number 4. Question 39. The charge in this case involves allegations regarding exposure to one or more sexually transmitted diseases. Is there anything about such an allegation that you believe would affect your ability to serve as fair or impartial as a fair or impartial juror? Yes, I find transmission of STDs in a non-consensual act to be particularly repulsive. Question 55. Have you ever known anyone, including yourself, who was the victim of a sexual assault, other assault or homicide, other act of violence that require medical treatment for counseling? The answer was yes, you guys. They said close friend received asylum due to sexual assault and infection with HIV from the police in a foreign country. You mean to tell me nobody had enough sense to kick this juror? I can't even stay on this one. But this is ridiculous, you guys. I don't even want to read that again because it's so preposterous. Question 78. Which publicly known person do you least admire? The answer was Jeffrey Epstein. Although the court generally asked whether anything the juror read would affect his or her ability to be fair and impartial in the case, the juror replied, "Not that I know of." Okay, boo, that's a pointed question. That means yes or no. Okay, you can't answer "not that I know of." Okay. With that being said, but trial counsel did not ask the court to question the juror whether his feelings of repulsion about the transmission of STDs in a non-consensual scenario would interfere with his ability to serve as a fair and impartial juror. No conceivable reason exists for failing to inquire further about the juror's feelings about the transmission of STDs in non-consensual circumstances where the government charged the defendant with precisely that act. Incredibly, this juror willingly disclosed that the publicly known person he least admires is Jeffrey Epstein, an accused pedophile, just like the defendant, with no meaningful inquiry about whether this juror could truly serve as a fair and impartial juror. The juror was seated. Wow. Let's get the legs of jury number 5. Disclose the following in his or her questionnaire. Question 31. Have you watched or heard any interviews of Robert Kelly or any TV shows featuring him or any special documentaries about him? Yes. What were your general impressions? He loves underage girls. Y'all see that? You guys, you mean to tell me that this juror didn't get kicked? Let me read it again for you. What were your general impressions? Okay. After seeing the documentary about him, he loves underage girls. And you see she got it in the big bold print. Because she wants you to see this. She wants you to see this, yes. And she wants you to see this big bold print of he loves underage girls. She emphasized that. Bold means emphasis. Okay, question number 32. From what you have seen or heard, do you have a general impression of defendant? The answer was somewhat negative. Woo-wee. Why do you feel that way? The answer was the allegation that related he was sleeping with underage girls, parentheses, minors. Although the court asked the prospective juror general questions about her ability to put aside other things she might have heard, when she asked if he or she could be fair, the juror indicated that he or she would give it a shot. Once again, that's a pointed question. When asked if if he or she could be fair, that's a pointed question. That brings a yes or a no. The juror indicated that he or she would give it a shot. Woo, Jesus. Kales. We didn't even know you were going through this, Kales. This is pitiful. I know you were sitting up there like, my God, my Lord, my God. I'm going to continue reading. This is pitiful, though, you guys. This is pitiful and sad. The court reminded the juror that he or she had to be certain that she would consider only evidence offered at trial. The juror acquiesced. Okay, let's go on and see what, because they keep on coming with, acquiesced. Google, what does acquiesced mean?
Here's the definition of acquiesce. Accept something reluctantly but without protest.
There you go. Accept something reluctantly but without protest. Basically going along to get along. Okay. Incredibly, the court seemed very concerned about the juror's ability to be fair, observing, "So, I don't know about you, but when someone says they think they can do something in this context, I don't think that that's a unqualified assurance. And I don't know what the party's position is on that. I think I pushed her pretty hard on it, and we still ended up with, I think so." Basically, she's saying that the defense tried to question this person, and they answer was they still beat around the bush, and they came back with, "I don't think so." Let me hear from the government if you have a position on that. Not surprisingly, the government went along. The government was confident that the juror indicated she could be fair. The court still expressed doubts. Inexplicably, trial counsel agreed with the government, and the juror was seated. Woo-wee. This is pitiful and sad. To be blunt, defense counsel agreed to the seating of the juror, who not only watched the documentary Surviving R. Kelly, but concluded that defendant loves underage girls. There simply cannot be any that's the typo, I guess, right here. Any trial strategy for failing to excuse this juror for cause. Had trial counsel challenged this clearly unqualified juror, the court seemingly would have struck him or her for cause. Trial counsel not only didn't move to disqualify the juror, he did not even ask the court to probe more deeply into the juror's statements on the questionnaire that the defendant loves underage girls. Number 7, let's get his legs. Also revealed in this questionnaire that he had heard about the case and the alleged crimes. Trial counsel did not ask the court to question the juror further about what he heard specifically or where he heard it. The court merely asked the juror whether he could put aside what he heard and rely on the evidence presented in the case. Juror number 8, let's get their legs, also disclosed that he or she heard about crimes the defendant is alleged to have committed, and further indicated that he or she believed that the allegations related to another case in another state. Woo! And further indicated that he or she believed the allegations related to another case in another state. Come on, y'all. This is juror number 8. Also disclosed that he or she heard about crimes the defendant is alleged to have committed, and further indicated that he or she believed that the allegations related to another case in another state. Kells, baby. Woo! You just ain't have a chance, babe. Again, trial counsel failed to probe what precisely the prospective juror had heard, or conduct a meaningful inquiry into whether she could be a fair given what she had heard. Okay, it's a couple typos in here. And I guess it's legal smeagol too, because sometimes it reads different. Ooh, they coming down the line. Juror number 9, let's get their legs. Also indicated that she knew the defendant had issues with the law. They think he's unruly, but could not say exactly what for. See what I'm saying? That's rumor right there. You heard something that he had issues with the law, even though you don't know what for, but you hold that negative connotation. Okay. She also described the Me Too movement as the power structure of the male-dominated move industry has been turned on its head. Let's read that again. She also described the Me Too movement as the power structure of the male-dominated move industry has been turned on its head. Okay, they mucked that up. But anywho, again, trial counsel did not ask the court to question this juror about any details she may have about defendant's issues with the law, nor did he ask the court inquire about the defendant's views concerning the Me Too movement and the role of changing power dynamics in the male-dominated movement. Okay, so they cleaned it up. They saying that she believes that the Me Too movement is changing the male-dominated, the power dynamics in the male-dominated movement, basically. Okay, that's what they're saying, and that's accurate. That's what they're trying to do. But you guys, these are the jurors that Kales was subject to, and this is sad. Juror number 11, they coming down the line, similarly disclosed that he or she saw the case, and Kales is also he got to be free, you guys. He has to get a new trial, and we're gonna read the acquittal. We might even just say, Jesus, send the acquittal. But today we saying, Jesus, give him a new trial. Actually, we saying throw the trial out, okay? That's really what we're saying. So I guess they did saying acquittal. Okay, but juror number 11, let's get their legs. Similarly disclosed that he or she saw the case mentioned on the news when he first saw, when he was first being investigated, and that she had read or seen that he had allegations of misconduct lodged against him. Shockingly, trial counsel did not ask the court to follow up on any of these important revelations to determine whether the juror was qualified. Look, she done got the attorney's legs and the bogus juror's legs. You go, girl. One sentence, knock down two with one stone. Ooh, she coming down the line. Juror number 12 offer several concerning answers in response to the questionnaire. Question 29, have you read, seen, or heard anything about the case, the alleged crimes, or people involved? Answer was yes. Describe in detail what you recall reading, seeing, or hearing about, etc. Sex with minors. Specific details do not come to mind. Parodies on TV. Regarding details of defendant's personal life. SNL, which is Saturday Night Live, Dave Chappelle renditions, basically, was in jail prior, then released. Wow. Saying it right there. Sex with minors. Specific details do not come to mind, but TV parodies of SNL, Dave Chappelle. And they remember he was in jail prior, then released. Kales, baby, you ain't have a chance. They asked question number 30, have you read, seen, or heard about R. Kelly? Yes. The answer, same answer above. Various instances of achievement in musical career, songs on the radio, videos, entertainment news shows. Specifics are not remembered. 32, from what have you seen, read, or heard? Do you have a general impression of the defendant? The answer was somewhat negative. They said why, and the answer was, I really never cared one way or the other regarding the defendant. Big bold letters. The somewhat negative impression is an emotional one impacted by the nature of the charges against him. Did y'all hear that? The somewhat negative impression is an emotional one from, basically they're saying it's an emotional one for them, and it's impacted by the nature of the charges against him. So they're basically just saying because of the charges, they're emotionally affected, and that they're impacted by that. And basically they already have made a decision that they believe the negative charges that have been brought. That's pitiful. Question 91. Do you know anything about the Me Too movement? And the answer was entertainment industry led movement encouraging women to come forward and name their accusers. Associated with accusers of Harvey Weinstein, various news articles and TV news segments. Trial counsel questioned the juror about his or her ability to be fair and obtain assurances from the juror he or she could be, but trial counsel did not bother to ask the court to inquire about the juror's references to defendant's personal life, keyword personal life, sex with minors, or Dave Chappelle's SNL skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. It is beyond comprehension that trial counsel would not have sought. Let me go back to read that. We need to get that on the note. Which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. Or Dave Chappelle's SNL skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. Or Dave Chappelle's SNL skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. Moment of silence for that. For the dummies way in the back. We'll continue. It is beyond comprehension that trial counsel would not have sought to inquire further of this juror about his prior knowledge about allegations against defendant or press whether he could truly be fair given the information in which he came to the jury. Nearly all of the alternative jurors admitted that they were aware of allegations of sexual abuse against defendant. In fact, one of the alternative, listen to this, y'all. Listen to this. In fact, one of the alternative jurors stated, now there have been accusations related to this for quite some time. Think defendant was Mia, who was underage at the time, and further admitted that she had seen defendant's interview with Gayle King in which he stood up and yelled to defend himself. Although defense counsel indicated that he intended to challenge this alternate for cause, no motion was formally made and the alternate remained on the jury. Do y'all hear this? He stood up and yelled to defend himself as if that was a negative thing. Okay. You guys, I've mentioned this before and I still to this day have not seen that whole interview because I can't get past the way that he basically stood up and told them he was showing emotion. Okay. The man is fighting for his life. Like he said, he's not going to Disneyland. Okay. They're trying to give him a life sentence. So for him to stand up and so what is he supposed to be quiet and be like, oh my God, you guys, please believe me. I'm fighting for my life. I didn't do this. No, that's not how it go. Okay. And if you don't know, people from Chicago, we loud, we emotional, we do hand gestures, all that, pumping the chest. That's what we do. That's how we talk. We talk with our hands. Okay. Our neck, our face, everything. Okay. This right here just upsets me so bad because there's other people who really thought that too. Like, because he got, this ain't no time to be politically correct. He's fighting for his life. Let me go on because I'm getting upset. Although defensive counsel indicated that he intended to challenge. Okay, so basically, Kenny saying he intended to challenge this guy or person for cause, but yet he never filed the motion formally, and the person stayed on the jury. Can you believe this? Pitiful. Critically, alternate juror number 4 revealed that she was aware that defendant was married to Aaliyah when she was young, but claimed that she had not really heard much about the case and assured the court she could be fair. Again, trial counsel had no follow-up questions for this alternate juror. Notably, this juror apparently was familiar with the Me Too lawyer, Gloria Aldridge, who represented some of the government's witnesses, and asked if she could get Allred's autograph in the middle of trial. Let's take a moment of silence for this juror. This is how pitiful this jury was and how dumb this juror was. You supposed to be fair and impartial, and you go and ask for a freaking autograph from the attorneys who represented some of the government's witnesses. The attorney for the government witnesses. She didn't ask for Kel's autograph. I bet you if she would have asked for Kel's autograph, I bet you they'd have booted and scooted her up off the thing, y'all. That's pitiful. Pitiful and sad. Defendant had no chance to defend himself, where most of the jurors in this case were fully aware of his prior legal issues. Some had watched the damning documentary series Surviving R. Kelly, and many seemed to accept that he was known for abusing minors. Frankly, everyone in the courtroom seemed to accept that the defendant's jury would be prejudiced against him and made virtually no effort to impanel a truly unbiased jury. Although the court generally asked jurors about their ability to be fair, it was the counsel's job to elicit as much information as possible to determine whether the jury could actually be fair. They needed to confirm that the person could be fair. As stated previously, in this case of substantial pretrial publicity, jurors' subjective assessments of their own impartiality may not adequately screen for the possibility of prejudice. Exciting case law. Voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to the impartial jury will be honored. Case law again. As early, oh my God, my throat, y'all. As early as 1895, the Supreme Court in Connors versus United States case law explained an inadequate voir dire is essential to ensure that prospective jurors will be free of bias or prejudice and will perform their duties impartially. The primary purpose of voir dire is to make possible the impaneling of an impartial jury through questions that permit the intelligent exercise of challenges by counsel. Case law. Defendant received ineffective assistance of counsel where his trial counsel failed to conduct a meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. Counsel also failed to challenge jurors who were clearly disqualified from serving, including those who had been seen the highly. Let's say, let me go again. I got marched up. Okay. Counsel also failed to challenge jurors who were clearly disqualified from serving, including those who had seen the highly prejudicial documentary surviving R. Kelly to prevail on a claim of ineffective assistance of counsel, the defendant must demonstrate both his attorney's representation was unreasonable under the prevailing professionals' norms, and that there was a reasonable probability that, but for the counsel's unprofessional errors, that the result of the proceedings would have been different. Case law. And that's exactly right. Had they not made those errors, because nobody who saw the documentary should have been on the case, period. It's too damning and it was too prejudicial. And that's a fact. R. Kelly was doomed, okay, you guys. His character was smeared. It was assassinated before right after this documentary went out. He was done. You know, they were still holding on stuff from the 2008 case, and then the documentary came out. That sealed his fate. It was over with. And then you all know the progression from that. Trial counsel performance was unreasonable under prevailing professional norms, where he failed to question clearly by let's go back again. Trial counsel's performance was unreasonable under prevailing professional norms, where he failed to question clearly biased jurors about the extent of their knowledge about defendants' prior legal issues, allegations of sexual abuse, and their feelings about the documentary surviving R. Kelly. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise the defendant's preemptory. I think I'm putting too many syllables in that. Preemptory challenges without properly questioning potential jurors to learn of potential biases. In this case, numerous jurors divulged that they had prior biases from having learned information about the defendant through other sources prior to the jury selection process, period. In this case, numerous jurors divulged that they had prior biases from having learned information about the defendant through other sources prior to the jury selection process, period. Their own subjective assurances that could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about defendant's guilt. Significantly, one alternate juror saw Me Too lawyer Gloria Aldrich in the courtroom. Aldrich represented a few of the government witnesses and was a common fixture on all media platforms, declaring defendant the worst predator she has ever pursued. During the middle of trial, the jury asked a courtroom deputy, dumb. We got, oh God. I'm gonna refrain from what I was about to say. The juror asked a courtroom deputy if she could obtain an autograph from Allred. When asked by the court why she wanted the autograph, the juror responded, here we go, y'all, dum, because I admire her. Woo, Kels, baby. Kels, oh my God. This is pitiful. These are your jurors, Kels. Hang on, Kels. Hang on. They getting you out of there. Just because you know other cases I've never heard. I don't know. I'm sorry. Just because you know other cases I've never heard, I didn't know she was going to be here. I just admire her for what she's accomplished. This is the same alternate juror who admitted during the jury selection process that she knew about allegations against the defendant, and specifically that he was married to Aaliyah when she was underage. Trial counsel belatedly belatedly sought to remove the juror, stating, "I can't think of anything more disqualifying than a juror asking for an autograph from one of the attorneys who represents one of the witnesses. It speaks to the bias of the prosecution's witnesses, and for that reason, I would ask that she be removed." The request was denied. Kels is getting another trial. Oh, they gonna have to throw all of this bullshit out. He got to. This is too many infractions. They have listed. I didn't even take a note of how many jurors are flawed. They flaw and foo-foo. Trial counsel was, of course, correct that this juror clearly evinced a bias against defendant and in favor of his accusers, but counsel's failure to ask the court to question the juror during voir dire more extensively about her factual knowledge of the defendant's marriage to Aaliyah and her feelings concerning allegations of sexual abuse made it impossible for the defendant to gather an accurate impression and to make an educated decision about whether she was qualified to serve. Had counsel competently questioned this juror, he likely would have learned information that revealed a bias consistent with her request to obtain an autograph from Alred, a woman she admired, who called defendant the worst predator she has pursued. Defendant demonstrated prejudice by trial counsel's failure to conduct a meaningful voir dire where his jury was comprised largely of the people who were seated with an understanding that defendant was a sexual predator. Because defendant cannot possibly prove the likeliness of success in his case was heard by a fair and impartial jury, prejudice must be presumed. Let's read that again. Because defendant cannot possibly prove the likeliness of success if his case was heard by a fair and impartial jury, prejudice must be presumed. Trial counsel abdicated all responsibility to conduct a meaningful voir dire, which resulted in a juror that was largely unqualified to serve. The United States Supreme Court has recognized that in certain Sixth Amendment contexts, prejudice is presumed. Actual or constructive denial of the assistance of counsel altogether is legally presumed to result in prejudice. Like cite case law. This case is one of those rare cases. Accordingly to this court, should be vacated the verdicts of guilt and grant defendant a new trial. B words. I added that. Okay, and now number 2. She got down. Let's go. Bon Jean's team, they didn't put their foot in this. They didn't got the legs. They came down the line and got the legs of all these jurors. Pitiful. 2, defendant is to, we almost done, you guys. Hang in there with me. Defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government's star witness, Jane, that was imputed to the entire defense team. Defendant is entitled to a new trial where he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of trial, it was discovered that one of the defendant's attorneys, Ms. Becker, may be suffering from a conflict of interest because her prior representation of the government's key witnesses, Jane. Consistent with its obligations, the court conducted a cursio hearing and concluded that Ms. Becker had entered an attorney-client relationship with Jane while she was representing the defendant. Although this conflict was unavailable, I put that word up in there. You see how color folks will do. Although this conflict was an unwaverable conflict, the court permitted defendant to waive it. Because defendant was denied conflict-free counsel by an attorney who likely possessed information that could have been used to discredit Jane's testimony, but was unable to utilize the information without revealing attorney-client communications. The defendant was prejudiced by this conflict. Let's go. That's clear as day right there. I don't even know what Keller was stumbling and mumbling about. That's clear as day. That's reading comprehension 101. You learn that in what, 5th and 6th grade, maybe even in kindergarten. Okay, that's clear as day. And let's read that again. Consistent with its obligations, the court conducted a cursio hearing and concluded that Ms. Becker had entered into an attorney-client relationship with Jane while she was representing the defendant. Although this conflict was unwaverable, although this conflict was an unwaverable conflict, the court permitted defendant to waive it. Because defendant Kales was denied a conflict-free counsel by an attorney who likely possessed information that could have been used to discredit Jane's testimony, but was unable to utilize the information without revealing attorney-client communications. Defendant was prejudiced by this conflict, period. Say rocket science, reading comprehension. The Sixth Amendment mandates that all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. U.S. Constitution Amendment 6. This right to counsel includes a criminal defendant's right to be represented by the counsel of his choice. Case law. However, this qualified right is supported by, among other things, the Sixth Amendment right to effective assistance of counsel. Case law. A defendant's Sixth Amendment right to effective assistance of counsel includes the right to representation of conflict-free counsel. It's written. A per se conflict of interest exists. One, where an attorney was not licensed to practice law because he failed to testify the substantive requirements of admission to the bar. And two, where the attorney was implicated in the defendant's crime. Case law. The per se rule applies when an attorney is implicated in the crimes of his or her client, since in that event the attorney cannot be free from fear that a vigorous defense should lead the prosecution or the pretrial judge to discover evidence of the attorney's own wrongdoing. Case law. An attorney has an actual as opposed to potential conflict of interest when during the course of the representation an attorney and defendant's interests diverge with respect to a material, factual, or legal issue or to a course of actions. While a defendant is generally required to demonstrate prejudice to prevail on a claim of ineffective assistance of counsel, this is not so when counsel is burdened by an actual conflict of interest. Prejudice is presumed under such circumstance. That's case law. So basically what they're saying, you guys, is Nicole Beckham, by her already establishing an attorney-client relationship with Jane Doe, that even though they waived that she could still remain on the case, her attorney-client privilege with Jane Doe was still in effect. And with that being in effect, the Miss Becker was not able to use any of that information to support her current defendant. So her current my brain is going down. Her current client, which is Kales. Okay. So basically, because Nicole Becker had a previous attorney relationship with Jane Doe, it was still in effect. And the information that she retained could not be used. She couldn't use it in the Kells case because she had to maintain her attorney-client privilege with Jane Doe. I'm sorry, not Jane Doe, but Jane. It's tired, y'all. Okay. We almost done, y'all. Hanging in. In the case at bar, defendant is entitled to a new trial where his attorney labored under a per se and or actual conflict of interest that could be waived. At a crucial hearing held on July 15th, 2021, just weeks before the commencement of trial, Jane's prior attorney, Ms. Rodriguez, disclosed to the court that she was previously retained by Jane and another possible government witness, Jay Savage, in July 2019. Rodriguez met defendant's attorney, Ms. Becker, in person at a bond hearing at the Dirksen Center in July 2019. Ms. Rodriguez expressly told Ms. Becker that she represented Jane and Savage, instructing her not to contact Jane. Ms. Rodriguez provided a text message to the court that showed that Rodriguez, texted Ms. Becker stating, "I don't want the lines blurred regarding our role, and I think they are already blurred. Please do not contact them at all without my knowledge." Rodriguez told the court that she later learned that Ms. Becker had been contacting Jane and Savage. Oh! Ooh la la, la wee wee. Rodriguez told court that she later learned that Ms. Becker had been contacting Jane and Savage. According to Rodriguez, Jane suggested that she was getting advice from Becker in connection to how to handle the media. Rodriguez declined to divulge further information about her conversation with Jane, but stated that her representation formally ended when she received an instruction signed by Jane telling her to provide her attorney's file to her new attorney, Ms. Becker. Ms. Becker confirmed that she had communications with Jane. The government also confirmed that Jane had told prosecutors that she had a lengthy meeting with Ms. Becker in August 2019. The government revealed that in their conversations with Jane revealed information to the government that she received from Ms. Becker that the government reviewed as adverse to the defendant. The government revealed that in their conversations with Jane revealed information to the government that she received from Ms. Becker that the government viewed as adverse to the defendant. After considering statements made by Ms. Rodriguez, the court noted that Ms. Rodriguez stated that Ms. Becker had given her clients legal advice that conflicted with the advice that Rodriguez had given her client. Let's read that again. After considering statements made by Ms. Rodriguez, the court noted that Ms. Rodriguez stated that Ms. Becker had given her clients legal advice that conflicted with the advice that Ms. Rodriguez had given her. Oh, she's saying that she told her something different. This court seemingly concluded that Ms. Becker had formed an attorney-client relationship with Jane while she was representing the defendant, evidenced not only by Ms. Rodriguez's statements, but the fact that Jane instructed Rodriguez to send her file to Ms. Becker. Oh, okay. And let's make that note again. Let's read that again. The court seemingly concluded that Ms. Becker had formed an attorney-client relationship with Jane while she was representing defendant being Kells, evidenced not only by Ms. Rodriguez's statements, but by the fact that Jane instructed Rodriguez to send her file to Ms. Becker. The government further pointed out that Ms. Becker might suffer from a so-called Fulton conflict, which arises when an attorney, oh, here we go. Pay attention, you guys. The government further pointed out that Ms. Becker might suffer from a so-called Fulton conflict, which arises when a lawyer is accused of misconduct, whether true or not. In those scenarios, the attorney may violate his or her duty of loyalty to her client by prioritizing her own interests in defending herself against accusations of misconduct. And that makes sense. You're going to always cover your own behind before you about to be loyal to your client. You're not going to throw yourself under the bus for your client. It's just not going to happen. That's just against the law of self-preservation. The law of self-preservation is the first law of man, you guys. Don't ever forget it. Somebody's going to always look out for themselves before they're going to look out for you. You heard it here. The court acknowledged that Becker did suffer from a conflict, but that amounted to a conflict that could be waived and mitigated by ensuring that Becker did not conduct the cross-examination of Jane. This court afforded defendant the opportunity to consult with a third-party lawyer and admonished him before accepting his waiver of conflict-free counsel. This court afforded defendant the opportunity to consult with a third-party lawyer and admonished him before accepting his waiver of conflict. Okay, so they basically saying that they treated him wrong and saying that he can go talk to outside counsel, which he shouldn't have to do. They did Kels wrong, you guys. If you guys are listening to this, I'm going to read that sentence one more time. The court afforded defendant the opportunity to consult a third-party lawyer. Why do you have to do that when you got lawyers on deck? And admonished him, basically got down on him before accepting his waiver of a conflict-free counsel. Basically, it sounds like he was forced under the duress to sign a waiver stating that he was receiving a conflict-free counsel. That's what it sounds like to me. Okay, I'm not a legal smeekle, but that's what it sounds like to me. Defendant is entitled to a new trial where his attorney, Ms. Becker, labored under a per se or actual conflict of interest that could not be waived. And we talked about this before. Unethical. When they saying per se, that's saying possibly. Okay, unethical. Or actual conflict of interest that cannot be waived. First, as the government pointed out, Ms. Becker seemingly suffered from a Fulton conflict a per se conflict where there is no question that by communicating about the case with the government's key witness, notwithstanding that the witness had her own counsel and did not consent to communications, she opened herself up to accusations of misconduct. Woo! Let me read this again. One more again. First, as the government pointed out, Ms. Becker seemingly suffered a Fulton conflict, a per se conflict, where there is no question that by communicating about the case with the government's key witness, notwithstanding that the witness had her own counsel and did not consent to the communications, she opened herself up to accusations of misconduct or even possibly an attempt to influence the government witness on behalf of her client. Whoa, Charlie. Whoa, she getting down on him. That is not to say that the allegation is true, but an attorney who may be perceived, that's the word, possibility, the appearance of perceived as engaging, perceived as having engaged in that type of misconduct suffers a per se conflict, since the attorney cannot be free from fear that a vigorous defense should lead the prosecutor or the trial judge to discover evidence of the attorney's own wrongdoing. Case law. No, that's not case law. Fulton Supra. I don't know what that means, y'all. Second, when Ms. Becker formed an attorney-client relationship with Jane, her interests diverged from the defendant because she also owed a duty of loyalty to Jane, the government's key witness. Let's read that again. Second, when Ms. Becker informed an attorney-client relationship with Jane, her interests diverged from the defendant because she also owed a duty of loyalty to Jane, the government's key witness. You guys understand that? She couldn't be fully into Kels and support him wholeheartedly because she still had loyalties to her previous client and previous attorney-client communications and relations. So she couldn't fully support Kels because there was a conflict. She still had loyalties to Jane. The government's key witness. Miss Becker was placed under inconsistent duties because of her representation of the defendant and Jane, an adverse witness. Prejudice must be presumed where Ms. Becker had at least one extended conversation with Jane about her relationship with the defendant and may have obtained privileged information from the file that Jane's prior attorney sent to Becker at Jane's request. However, Becker was prohibited by the attorney-client privilege from disclosing any information she may have received from conversations with Jane or from her prior attorney's file, even if that information would have been beneficial to the defendant's defense. Similarly, as the government suggested, although the record is unclear on this point, Jane may have obtained privileged information from Becker that was adverse to the defendant, the information that most certainly was passed along to the government. Everybody be clear, the defendant is Kels. Woo! That's deep. Courts have recognized that where a lawyer seeks to simultaneously represent a defendant and a cooperating witness in the same criminal proceedings, a conflict of interest persists. Case law. They cite case law. Further, whenever a defense attorney has previously represented an important government witness who testifies against his client, the possibility of conflict of interest exists. They cite case law again. With these principles in mind, Ms. Becker suffered from an actual conflict of interest that could not be waived. Could not be waived. Bongine is saying it could not be waived. Okay, basically saying the decision of the judge was wrong. How else should I say it? That conflict was imputed to her trial partners. An attorney's conflict are ordinarily imputed to his firm based on the presumption that associated attorneys share client confidences. If Becker had merely interviewed or conversed with Jane, she would have had no duty of loyalty to Jane. That conflicted with her duty of loyalty to the defendant. Let's read that again. If Becker had merely interviewed or conversed with Jane, so they're saying that if she just would have had a conversation, then she would have had no duty of loyalty to Jane. That conflicted with the duty of her loyalty to Kels. But as the court concluded, Becker formed an attorney-client relationship with Jane that put her at odds with her duty of loyalty to Kels. The risk of prejudice was made more significant by the fact that Jane was not just any witness, but the government's star witness. The government star witness. Defendant's Sixth Amendment guarantee of a conflict-free counsel was denied. A light of foregoing defendant's convictions must be vacated and a new trial ordered. Dated February 17th, New York, Jennifer Bonjean, Jennifer Bonjean Law Group, New York, New York. Woo! We did it, you guys. We did it. We did it. Now I need y'all to come on here. I hope y'all understood that. But do you guys see what happened? Do you guys see? Do you understand the attorney-client privilege? Let's get the likes up, you guys. Let me see. I need at least 25 likes. Let's do a moment of silence for the likes. Let me see where we at. You all did good. Y'all hanging in there with me. We about to do a little panel, and then we're going to get up out of here. I want to know what you guys think about this preposterous violation of Kel's Sixth Amendment rights and the injustice of his case. Let's see where we at. 25. Good job, you guys. Thank you. I appreciate that. And everybody that's not subscribed, make sure you subscribe and hit the bell so you can before trial started, he was doomed. Period. Doomed. Hit the button when you hit the subscribe. That'll make sure you get the notifications. And if anybody's not getting notifications, all you have to do is unsubscribe and then subscribe right back, and hopefully it'll start sending you notifications. No way. He had no way for a fair trial. Okay, we're gonna do a panel, you guys. I'm about to drop the link. If anybody's in the bushes, come on out. Everybody's welcome. We're not doing that today. We're not doing that today. I don't care what nobody has said about nobody. I want y'all to come out. If my legal smeagles can come on, I definitely need to hear from you guys. I have a couple of questions for my legal smeagles. I hope you guys understood what was read. I'm just trying to go through y'all. Yes, he was being lynched right before our eyes. Yes, he was. Yes, he was. Yes, he was. That's right. God is going to turn this here thing around. I'm sorry, you guys. Y'all here. I was in here talking. I'm glad y'all was chopping it up while I was reading Our Channel by Andrew. Hey, what's going on? Who else did I miss? Hi to all the new people that came in. If anybody came in. Yes, right. This is a travesty. The government wanted Kelly so bad that they will ruin their reputation. Yes, their reputation is ruined too. Yes, exactly. That's exactly what happened. They have no problems of looking bad. What's going on, T-Man? They have no problems of looking bad. Leslie Jennings, welcome to the chat. Are y'all welcoming these people to the chat? I hope so. All minds, I need y'all to welcome everybody to the chat. Just say hello, boop, 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 boop. Goodbye, boop, 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 boop. That's all we need. You ain't got to like them. You know, you ain't got to love them. Just say hello and goodbye. Okay, let me drop the link so y'all come on up here. Let's get it cracking because we don't want to be too long. Oh, I was only on here hour 43, but I guess it is almost 3 in the morning. All right, you guys. Mods, please welcome people. That's very important to me. Let me see. Wait a minute. Copy. Paste. All right. I dropped the link. If I can get my legal smeagles in here. Hey, Dip, what's going on? I hope I didn't miss anybody. Come out the bushes. If you new, come out the bushes. I want to see you. Come say hi to me. Come say hello. Good job, Chi-Town. Saying hi to the people. Good job. She found everyone safe to get an acquittal. Yes, she did. She done got their legs together. Together, y'all. Together. Together. Ooh, y'all was in here chopping it up. Okay. Hey, Courtney. Hey. I'm just trying to make sure, say hi to all the people. Make sure I ain't miss nobody. Queen Diva. Niecy Mo. Hey. Did I say hi to Niecy Mo? Now, why y'all ain't blocked this one right here? Did y'all block that? Come on now, mods. Y'all tripping. Who my mods? Y'all, come on now, y'all. That shouldn't even be in my chat. Y'all tripping. Y'all done fell off y'all square. I'm taking points away. I'm taking points away. I'm gonna have to go back and see if y'all got that now. Get that up out of my chat. Yes, Dipped. All is definitely well. I see you. I hope y'all got that out of my chat. I don't even want to. It say Sly Fox. Get that out of my... Y'all, I hope that's not in my chat. Did y'all get that out of my chat? Why is that up there? We ain't doing none of that. Not today. We talking about chaos. Prayer changes. Welcome back. Is somebody coming in? I don't see nobody coming in. It's blocked. What you mean it's blocked? Is that what you saying? The thing blocked? I'm about to try it again. Oh, you blocked them? Okay. Okay. I know y'all ain't finna, after I read that, I know y'all not finna leave me in here by myself. Somebody better come say hello or something. Let's do a quick panel or something now. The link is in the chat. Come holler at me. We ain't gonna talk long. Okay. I hope y'all, I'm glad y'all on y'all job, because we don't want no shenanigans, y'all. That up. No cussing, Chatham. I'm gonna get you and A Peasy. Y'all gotta hit the cash app. Put my cash app up there. Cussing in the chat. That means you gotta hit the cash app. Nothing nice. Hey, how you doing? Welcome to the chat. I think you were here before. Nothing nice. Welcome back. Okay, we got Niecy. Let's do it.
Yes, ma'am. Yes, ma'am. We got a good one. We got a good one.
Niecy Mo.
Yes.
I can't
Hello,
hear you.
chat. Can y'all hear me? Can you hear me? Hello? Can you
I
hear
can
me?
see you up here, Niecy Mo, but I can't hear you. I can't hear nothing you saying. You know what? Is it me? Hold up. You know what? Hold up. It might be me because I don't have my hold on, it might be me. I don't have my thing plugged in. Okay, try and say something now. Oh,
Hello?
wait, hold on. Hold on. Okay, try and say something now.
Hello?
Okay, yeah, that's me. I ain't have my speaker. I can hear you now.
You can hear me now. Thank you, thank you, thank you. Oh, wow. I mean, we're just happy. We're excited. And I know the chat is excited. We're just ready for great things to happen. We're ready for Robert to come out. We don't want no redo. We don't want none of that. We just want these charges gone.
Mm-hmm.
Because they shouldn't have never come. They shouldn't have ever come. And everybody that it gets even better when you get to reading it. I mean, these people did some dirty, dirty, dirty stuff. They did some dirty things. They did some dirty stuff. And everybody was wondering why, she got rid of the attorneys, but she had to get rid of the attorneys in order for her to do her job effectively.
Yes. Yes. And I'm so glad that oh, y'all coming in here. Come on in here. Y'all come on out that bushes. Enemy lover. What's going on? Yes, you have been subscribed. Get out them bushes. I know you people up in them bushes. Come out of them bushes. You ain't got to be in the bushes. Scorpio. One deep. What's going on? Yeah, Chi-Town, stand up. Come out them bushes. Y'all ain't got to be in there. We don't bite.
Not at all.
They said that nothing. They said the same thing. No new trial. Overturned, period. That's right.
And we don't want it to come back ever again. Ever. You can't come back on him with this no more.
Right. Do not want it. We're not
accepting that. We're not accepting any of that. And sorry, Miss Becker, but if you riding dirty, we can't have you on the team, boo.
No, not at all. And it's sad because she was compromised, and people thinking that based on what the judge said. See, that's why it's checks and balances in this here thing, because when you have just because the judge said that a waiver could be applied doesn't mean that his rights are not being violated.
Exactly.
So
and my thing is that there, and it gets even uglier the more you get into it. I'm not going to I'm not going to divulge all the information, but it gets even uglier. And this is where I believe, this is my opinion. This is not in there, but this is my opinion. You were playing with you was playing on the prosecution side. You played the prosecution side the whole time. I feel that you deliberately went in there and said what you said because they gave you an ultimatum, and you did exactly as they told you to do, to go in there, and you said when she said that find him guilty. What do you mean find him guilty? This is not your first time practicing law.
Right, absolutely. Give me 1 second, Nissimo. APZ, make sure you blocking these people. Make sure you block them. Ain't no timing out. Put the hammer on them. Okay, go ahead, Nisi.
Yeah, when she come in there talking about no, Robert shouldn't be having to deal with that, saying get her down, take her down, any of that. He shouldn't have had to go through that. You knew that you had to compromise, and the way it's presented, she knew that Jane had already flipped before Robert knew it.
Mm-hmm.
You didn't even share that information with your client that she didn't flip.
Right, but she couldn't, because after reading this, we see that she still had loyalties and client attorney privilege still was in order. So she was.
How you got client privileges with her and you got client privileges with him?
There lies the problem, and that's why he needs a new trial. There lies the problem right there, and that's why he needs a new trial.
And I'm here to tell you, and anybody that was working with this woman, they may want to go ahead on and just bow down and move around, and because I'm telling you, I know people like that. They ain't going down by themselves.
They said that's the reason why they kept attacking Cannon. Yep.
Exactly. They're not going to go down by themselves. But hold on, back up. Oh, baby, it gets you see, we just got to the surface. It's some other things in there too. So don't give Kenneth a pat on the back yet, just yet. It's some other stuff it gets greasier.
Wait, she said Greenberg is still involved with this attorney.
Huh?
Queen Diva said, I want to make the people aware Greenberg is still involved with this attorney.
Well, I have a question to Queen Diva. Is this the Queen Diva that works for the MDC?
I don't know if she's going to disclose, but she's a legal smeagol, so she knows something legally.
Okay, but I'm questioning, but if she works for the MDC at the same prison Rob works for, it was some things that was said over there on the other channel. That's why I'm asking that.
They gave him independent counsel. I don't know what that means. They gave him independent counsel.
They did. The counsel that they gave him was the person. Remember the counsel when Greenberg was off the case, and he had the counsel that came in and stepped in until they got everything straight.
I do remember that, to stand in. Okay.
Well, that person was the counsel that was there, and to talk to him. But for those that don't understand, Robert is not your average person to understand clearly. You have certain people that knows how to talk to him for him to get a clear understanding. Now, if you talking that attorney lingo, and he nodding his head saying, yeah, he understand. He don't understand.
Why is it not letting me do a block on this? Hey, hold on. Let me talk to my mods. Mods, don't have anybody. I want you to block. No timing out.
You have to block them. I think you got to get them out.
It won't let me. I'm trying to do the.
For some reason, we can't do it. You have to do it.
For real?
Yeah, we can't get them out completely. You have to get them out.
It's giving me an error message. This is okay. I'm gonna take care of it later. Y'all keep on doing what y'all doing. Thank you for doing that. I'm thinking that y'all could do it. Okay, sorry about that, you guys. I'll take care of it later. Because right now, when I try and do it, it's giving me a
I don't know why, but you have to do it. That's something that you have to do.
When did they start that? Because y'all was able to block before.
No, we was able to time them out.
Oh, I thought y'all was blocking too. Okay.
No, we was timing them out.
Doggone it. Okay. Dang. All right, you guys. I'll take care of it later. But thank you. Continue to do that. Go ahead, Nisi. I'm sorry.
Yeah. But I mean, we gonna take what God is already doing, and God is already he's making a way out of no way, and he's opening the door. And I'm not going to stand on anything else but that door is getting ready to be open. Chi-Town, mama's getting ready to walk her son down them steps. And he gonna sing the victory song, and we going to have a Holy Ghost party right there on their campus.
He said he could have kept her if he got rid of Nicole. Okay. The independent counsel. We don't know about that independent counsel. But yes, absolutely. I feel this is a walk. I mean, if they do not, this stuff is cut and dry. They came down the list of the tainted jurors, and then she came in with detail about Becker. So you have a tainted, right now it's already established of a tainted jury. And
okay, Skyye. Do you remember in the beginning when the Judge Donnelly said they did not inform her about his reading abilities? Him not being able to read, and she said that they should have informed her long before now. She would have sought help for him.
I missed that. I didn't know.
Yes.
You saying that? Who said that?
And Donnelly.
Really? She didn't know that?
That was not, she said that information was not given to her.
Baby back. That means that, okay, let me, hold on. Y'all give me a second. I want to look something up. I want to see if, let me see if it'll let me remove this. Stop the screen. Okay. Niecy, you can go ahead and talk while I'm pulling this up. Go ahead and talk.
Okay, I see what Queen Diva said. She said that the judge explained in plain English that Nicole would pick her career over him, that he could not use her if he was found guilty. I personally wouldn't want to be using anybody that helped me to be found guilty.
Sure wouldn't.
Why am I going to use you? What are you going to do different if I'm, for the appeal process? What are you going to do different? And even going to the to the Chicago, what are you going to do different?
Right. Share screen. Okay, let me see this right here. Okay, you guys. Can you see the screen? Hold up. I want to make sure y'all can see this. Hold on, let me go back to it. Knock this over. Judgment of acquittal. We definitely not reading this tonight. And I put the link in the chat. If you all want to come up here, then come on up here, because we're going to close it out soon, because I know it's late and people got to go to sleep. But we will be back to discuss this. But we're going to go over this little table of contents real quick. Okay. Argument. The government failed to prove defendant guilty of the offense of racketeering. Oh, didn't we say that? That the record didn't Skyye Lyfe say that the racketeering one met? Along with other
yes,
bloggers. Okay.
Yes.
Government did not establish an enterprise. What? The government did not establish an enterprise.
Yes.
Are you saying that there's no enterprise? No enterprise was identified?
There was no enterprise.
What? Okay, hold on. Matter of fact, I think I know what to do.
One man ain't no what enterprise.
One man ain't no enterprise. I think we have definitely heard that one before, ain't we? Now, you know what?
And public opinion is not the law.
Exactly. I think y'all said that one, didn't you?
Yes, ma'am.
Didn't y'all say that?
Yes, ma'am. We did.
Okay, I think I got this. I had to do this from my phone, you guys.
Oh, okay.
So let me know if anything else pop up, and I'm gonna come on in there and come right behind y'all with the whammy.
Yeah, okay. Public opinion is not the law.
Yes, you all did come with that. Okay, we own it. Okay, let me go through these real quick. Let's see. Common purpose, enterprise distinct from racketeering activities, person enterprise rules. The government failed to prove that the so-called enterprises activities affected interstate commerce. I said that. I made the comment because when you're talking about racketeering, everything that is involved in the racketeering is supposed to be for the purpose of making some type of money off of that nefarious act. Okay.
Exactly.
I stated that. But of course, you know, the people over there on the opposition side tried to act like I didn't know what I was talking about. Okay. The government's proof did not establish a pattern of racketeering. We stated that too, that it was gaps in there because it's supposed to be continuous activity to establish a recall. We mentioned all this, you guys. We mentioned this. Racketeering Act number 1, bribery, exploitation of children, the child Stephanie.
Somebody's supposed to be continuously getting paid along with him. There's supposed to be some ongoing money going on somewhere,
Yes.
and none of that was
With
happening.
the enterprise that wasn't established. Yes, all of them were supposed to be working in concert to do these nefarious acts continuously for the purpose. His sole music career was to be for the purpose of these nefarious acts and to make money off of it. Wasn't met. Also, they do break it down. They talk about Geronda, Racketeering Act 7, sexual exploitation of a child, Geronda, Racketeering 8, Mann Act violations, Jane, Racketeering. I have got to go. Let me just go to page 29, you guys. I'm sorry, because I need to coercion and enticement, because we're going to go through this, you guys. It's long now. I might have to break it up, or either I'm just curious. Let me just go to page 29, because I think this is where and shout out to Dana J. He sent me some information. And he told me about the let me go to page 29 about how they got down on the parents that everybody wants to protect. I deserve an apology, and I'm not accepting it, just so you all know. $17. Oh my God, y'all. They talk about Demetrius. Let me see what this say right here. The government failed to prove Racketeering Act 1 where insufficient evidence existed to prove that defendant caused Demetrius Smith to pay the public. Let's go, John Bon, Jean, Jean, baby. Oh God, y'all, I ain't gonna be able to sleep tonight. The government failed to prove Racketeering Act 1 where insufficient evidence existed to prove that Kales caused Demetrius Smith to pay a public aid employee $500 to secure identification for Jane Doe number 1 Aaliyah. Despite blatant strong arming by the government, Smith's testimony was inconsistent and vague about whether the defendant was even present during any discussions about paying money to bribe someone for the fraudulent identification. Smith consistently testified that he discussed the prospect of bribing someone to obtain fake identification with Daryl McDavid. Smith did not obtain any money from Kales and did not recall discussing it with him, although he allowed that he might have. Whenever Smith failed to testify precisely as the government wanted, he was refreshed with his prior statements, not because he needed refreshing, but as a clear reminder that if he contradicted himself, he could be charged as a co-conspirator. Woo! Oh my God. Do you all hear that? Basically, the government was using a bully tactic right there. Oh my God. I didn't even read that, you guys, and it was right there. That type of bullying pervaded Smith's examination and suggested that Smith's testimony may have been pressured by the government. Oh my God. I swear to God, I didn't even read that. And I knew right there that that's a bully tactic. Refreshing his memory, letting him know we got you on the line. If you don't say what we want you to say, we locking you up too. This gangster right here, you guys. This gangster robbery without a gun, man. They lynched Kales without a gun. Let me go down to here. Woo, y'all, I'm gonna be up. I'm gonna be up, baby. Hold on, what does this say? I don't even want to hear about Stephanie. Oh, they got down to the nitty gritty. I don't care what none of them other people say. This is well written. This is deep. This is pointed. This is beautiful. And if they deny him, y'all, we taking it to the top. I'm sorry. I want to hear what they said about if anybody knows what Jane Doe's part where it comes in at about her parents. I thought it was 29. This is Geronda. Let me see what they're saying about this one. No rational juror could conclude based on evidence adduced at trial that defendant knowingly obtained or agreed to obtain any labor or services from Geronda on January 23rd, 2010, a conviction of forced labor under requirements of the government to prove, requires the government to prove beyond a reasonable doubt that one, the defendant obtained the labor or services of another person through inter alia, threats of serious harm, and 3, the defendant acted knowingly. Kales acted knowingly. Okay. The language by means of contained in the forced labor statute requires the government to establish a causal link between labor and services provided by the person and the threat of serious harm. Serious harm for purposes as divided. Harm, whether physical or non-physical, including psychological, financial, or reputational harm that is sufficiently serious under all surrounding circumstances to compel a reasonable person of the same background and in the same circumstance to perform or to continue to perform labor or service in order to avoid incurring that harm. What did Skyye Lyfe say yesterday, you guys? When I was on the panel over there and everybody said I was crazy. My question was, what harm was caused? Okay. Now, I might not be a legal smeagol, but I got common damn sense. You have to, it's staying right here. It's right here. And they're saying that you have to prove a threat of serious harm. There was no harm. There was no harm. Let me go down. Hold on. Let me go down to 25. I'm going to say it again. Everybody is welcome. We ain't finna be in here long because I'm telling you, y'all, I should have stayed. I wanted to be an attorney, but I was sick of school, you guys. Real talk. I'm not even going to lie to you. I was sick of school, even though I had to go back again. Racketeering at age. Okay, wait, here we go. She concedes. Here we go, y'all. The government failed to prove that defendant committed Mann Act violations in connection with his sexual activity with Jane on or about April 28, 2015 and May 1st, 2015 in the state of California. Jane was 17 years old in May 2015. She concedes that she misrepresented her age to defendant when she met him and kept her true age secret until fall 2015. After meeting defendant in Orlando, Florida in April 2015, Jane traveled to meet him in California at the end of April 2015. The government charged defendant with 2 Mann Act violations in connection with this trip, alleging first that defendant violated Racketeering 8 transportation, primarily the government's use of the Mann Act under the present set of facts is unprecedented and unjustified. Damn it. Let's read that again. Primarily, the government's use of the Mann Act under the present set of facts is unprecedented and unjustified. Provides that whoever knowingly transports an individual in interstate or foreign commerce or in any territory or possession of the United States with intent that such individual engage in prostitution or any sexual activity for which any person can be charged with a criminal offense or attempts to do so, shall be fined under this title or imprisoned more than 10 years or both. The government contended that Kales arranged for Jane to travel to California with the intent of willfully exposing her to a contagious infectious disease or communicable disease in violation of California health and safety codes. The government failed to prove the Mann Act under where it offered insufficient evidence that defendant transported Jane with the intent of exposing her to herpes, and 2, committed a violation of California health and safety code by proof of beyond a reasonable doubt. You guys, and I'm going to say this to all the bloggers and all the people out here that have been on Kale's side, you know, they wanted to make us act as if because we don't have a legal degree that we're stupid. Okay, but a lot of this stuff comes down to common sense. Okay, if there's a part when it has to be legal, and then there's a part when it has to be logical. Okay, and 1 after 2 after 3 after 4. Okay, 1, then you don't go to 5. You see what I'm saying? The natural progression of things. We understand what's not met. We understand that this doesn't equal to that. That's clear as day. You don't need a legal degree to understand that. Intent. Okay, and look, y'all, I'm gonna start reading this. We're gonna get out of here in a minute. Wait, hold on. I thought I heard a boop. Oh, Nisa, you got kicked out.
Yeah.
Okay, you back?
Okay.
Okay.
Back.
Hold on. I'm gonna put the link in there again if somebody wants to come in. This is really interesting. I see what he's saying. When you go to this, you don't want to you don't want to come out. Okay, let me go back. It says intent. Because there was no link connecting defendant's transportation of Jane with an intent to expose her to herpes, defendant cannot be guilty of the Mann Act violation. The 9th and 10th Circuit Courts of Appeal have held that to establish the intent requirement of the Mann Act violation, the government must prove that the illegal sexual activity is the dominant, significant, or motivating purpose behind the transportation. There you go. It's so much, you guys.
It's a lot. And I can honestly say that it's a lot that people don't know about that's going to come out, because whatever's done in the dark is going to come to the light. And everybody.
Did you get kicked out again, Nacy?
Can you hear me?
I can hear you now. Okay, go ahead.
Yeah, I says it's a lot that a lot of people you're not gonna see. It hadn't come out, but it's gonna come out, because whatever's done in the dark gonna come to the light. And a lot of these, well, I'm not gonna say a lot. Everybody played a part, and whatever their part is that they played, they better be ready to reap repercussions behind it.
There you go. That part. I'm about to read this real quick because this is interesting right here to me. In fact, the government cannot even show that motivating purpose of the trip had anything to do with Jane, as Jane herself testified when asked. Question: and while you were 17, did you take additional trips to California with the defendant? Yes, I did.
Yes, I did.
Do you remember where you traveled to? I do not. Do you remember what the purpose of your travel was? He has shows. Wah, 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 wah. In short, no rational juror In short, no rational juror could find that the government proved that the defendant's intent to transport Jane to California was to infect her with herpes. Woo! See, they breaking this here thing down. I love it. I love it. Let me see. Okay, I'm gonna just see where they talked about the girl mama, and then we're gonna get up out of here. This is wonderful. I do want to just sit down and just read this whole thing. They're based, because stuff that we think and that they thought was met, it wasn't met. Because this is what I'm trying to tell you.
Remember, Banjane said she has been watching and following this case long before she even came on board.
Oh, I didn't know that. Oh no, I'm about to read this right here. And see, this is the thing. This is what I kept saying. And Skyye, and they know Skyye Lyfe kept saying that the evidence is BS, and this is proving it. And I'm standing on it, and I'm saying it again. This proves that the evidence you guys proclaimed that was so great is a bunch of BS, and it wasn't met. The Mann Act wasn't met. The Racketeering wasn't met. I just don't have time to read it all, but I'm sure in here it says it. Okay. Now let's talk about these herpes that you all love to talk about. Okay, as written, the law fails to provide adequate definitions that put individuals with any chronic and potentially contagious diseases on notice of what amounts to criminal conduct, including communicable diseases that are not sexually transmitted. By way of example, nearly 50% of the population has herpes simplex 1. Let's say that again. By way of example, nearly 50% of the population has herpes simplex 1, a communicable disease. Under the 2015 statute, anyone with herpes simplex 1, also known as cold sores, who kisses another person without disclosing that they have herpes simplex 1 is guilty of a misdemeanor, even if the afflicted person has no active infection, outbreak, or does not pass the disease along to the recipient of the kiss. Under this statute, parents with herpes simplex 1, again 50% of the population, would be prohibited from kissing their own children. One cannot imagine how many arbitrary prosecutions could take place in this current era of a pandemic if this law was in effect today. She's making a mockery of you dummies trying to support this herpes transmittal. Oh my God. Even if the elements of the statute were, as the government alleged, insufficient evidence existed to sustain the charge. The government did not prove that Kales was contagious, infected, or had the capacity to transmit herpes during the sexual encounter he had with Jane in May 2015. Additionally, the government cannot show that defendant actually willfully, with knowledge of the consequences. Presumably, the government assumes that the consequences is transmitting the disease to the person being exposed. But effective treatments exist for herpes that significantly reduce outbreaks and the likelihood of transmission. Okay.
But
Let's
the
go back.
doctor said he did not have herpes.
Right. Hold on. I'm going to go back to what this is saying. I'm about to read it again. Okay, because I kind of brushed over it. Okay, the government did not prove right here, the government did not prove that Kales was contagious, infected, or had the capacity to transmit herpes during the sexual encounter he had with Jane in May 2015, dummies. It says right here. While you all want to argue that he had it and that the doctor came and said, boop, 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 she's shutting it down and she's saying she disagrees. She's saying that they didn't prove it. So shut it up. right here, and I'm letting you guys know where to go. Page 33 of the long document. What paragraph is this? Shut them up, y'all. Shut them up. Let me see. This looks like the third paragraph. 1, 2, third paragraph, page 33. Shut them up. We knew we was right. I kept saying they swore fighting with that herpes stuff. Didn't I say that? I kept saying that. If defendant consistently taken Valtrex in April 2015, it cannot be said that he let's go. It cannot be said that he willfully exposed Jane with knowledge of the consequences, particularly since Jane was not infected with herpes in April 2015. Woo! Wow.
That was their doctor. That wasn't his doctor. That was their doctor.
There you go. This is great, you guys. This is great. All that crap they were saying, it shuts it down. All right, you guys. Let me I wanted to see something about the girl mama. Okay, well, here we go. Woo-hoo-hoo. Oh, let's get it. Let's get it. Boom, 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 boom. I need somebody. Misty mouth. Oh God, Sandra. This is too funny. Okay, wait, let me. Oh my God, it's so much. I was trying to, just read a paragraph. Okay, let's go.
No, baby, it's a lot.
Yeah, she gets her legs. Oh, I done knocked over. Lord have mercy. I got to clean this room up this weekend. Okay, here we go, y'all. This is the last thing I'm reading. I'm laying no, but this last thing I'm reading. Okay. Racketeering Act 8B, coercion or enticement. The government alternatively argues that Kales is guilty of the Mann Act stemming from his April trip to California because defendant knowingly persuaded, because Kales knowingly persuaded, induced, enticed, or coerced Jane to travel to California. Insufficient evidence exists to prove that defendant took any action to induce, persuade, entice, or coerce Jane into traveling to California in April through May 2015. Quite the opposite. Quite the opposite. The record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter, comparing her to Aaliyah at various points.
Thank you.
My God is great all the time.
And all the time, he's great.
Blowing it up in their face. Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter, comparing her to Aaliyah at various points. The government takes great umbrage to this characterization, but the record speaks for itself. Although defense counsel did not make much out of it, government's exhibit 233 offers powerful evidence showing that defendant had no reason to induce, persuade, entice, or coerce Jane into going to California with him. Text messages introduced by the government show that Jane, with the guidance of her mother, enticed defendant who reasonably believed Jane was 18 years old, to bring her to California. In short, when Jane traveled to meet defendant in California in April through May, she required no enticement, persuasion, or encouragement of any kind. Meaning what I always said, she went to him, she took the box to him, she wanted Kels to hit it, he had to beg for it. None of that. She wanted
And
to
she
go,
said he didn't.
and she went.
Said he wouldn't.
I'm telling you, she sent it to him. She wanted him to hit. Period. I'm sick of y'all. Read the, just like y'all say. Now read the motions. Read, y'all, all Kel supporters in the chat. Make sure y'all, when y'all talk to these people, let them know. Read the motions. The motion said that when Jane traveled to meet Kels in California in April through May, she required no enticement, persuasion, or encouragement of any kind. That means she wanted to go. She wanted to be there with him, and that's exactly what she did. Boy, y'all can go kick a rock. I want to say something else, but we being sweet today. On April 2015, Jane attended one of the defendant's concerts in Orlando, Florida. After the show, someone provided Jane with the Kels phone number. After the show, someone provided Jane with Kels phone number. Keyword someone. Jane attempted, let's go back. Jane attempted to text the number. Let's go back. Jane attempted to text the number on the phone and gave the paper to her mother. Jane attempted to text the number on the phone and gave the paper to her mother. Okay? If she's 17 and you have somebody giving your daughter, your minor baby, 17-year-old daughter, a grown man's phone number, and you all text him, hold on, let's keep reading. Although Jane did not reach the defendant, Jane's mother began texting Kels, posing as her 17-year-old daughter.
All right. Lock the parents up.
And y'all want to tell me that I can't say where are the parents? Y'all want to tell me that I'm wrong for making that statement? Where are the parents? I explained it before that thing could be looked at many different ways. Just because you all see something at face value, sometimes you got to stop and think. Okay? This girl testified against her mother and her father. And now it's coming back again. Jane's mother began texting the defendant, posing as her 17-year-old daughter, her 17-year-old baby minor daughter, kid daughter, just out the womb, 17-year-old baby minor daughter. Jane eventually communicated directly with the defendant via FaceTime and told the defendant she was 18 years of age. On April 2015, Jane's mother still, dirty dog. On April 2015, Jane's mother, still posing as Jane, initiated text messages with Kels and arranged for Jane to meet the defendant at a hotel in Orlando.
That part right there.
I want an apology for all y'all talking about and for all the Kels supporters who y'all tried to act like, where was the parents, like we was wrong. They was clearly working in concert. She was texting Kels on behalf of her daughters right here in plain text. Oh my God, I'm gonna be up. On January 2015, Jane's mother, still posing as Jane, initiated text messages with Kels and arranged for Jane to meet Kels at a hotel in Orlando. Government's Exhibit 233 shows that Jane and her mother knew from the start that Kels was interested in Jane sexually, believing that she was of legally consenting age. Before Jane's first meeting with the defendant, Jane's mother texted Jane stating, "This man trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He want to F-U-C-K tonight."
So go get ready. Go get ready. Go get your dress on. Go get your skirt on or whatever you got to get on and get it ready.
Oh, let's read that again. I skipped over that. Before Jane's first meeting with defendants, Jane's mother texted Jane. Okay, I'm thinking this was going to somebody else. So basically, the mama texted Jane
Telling her to get
stating
ready.
this
Watch it
man
up.
is trying to screw, but
Yeah.
I'm trying to make it business. He knows you're a singer, but he ain't playing. He wanna boot boot. Okay, despite that Jane and her mother were on notice that defendant was interested in Jane sexually, Jane's mother encouraged Jane to meet Kels. She told Jane to keep Kels' curiosity piqued. Woo!
Wash it up. Make sure you wash. Make
Now,
sure you clean it.
did we say y'all call him Pimp Low? We gonna have to call her Alice Low, cause baby back. Keep Kels' curiosity piqued and advise her about what she should wear to effectively entice him.
Say it again.
And advised her about what she should wear to effectively entice him.
That means douche. Clean it up,
There
baby.
you go. There you go. And y'all want to sit up here and try and say the mother was not trying to push her daughter on Kels? You are, all y'all is stupid. I've been saying it all along, but this right here shows that you done. We've been saying this the whole time. Y'all want to make Kels like he is some type of criminal and some type of predator, but clearly the mother right here is sending her child up. Sending a child up to be involved with him.
Let me go buy you these panties from Victoria's Secret because I need you right.
There you go. Okay, here we go. During her in-court testimony, Jane testified that she went to meet defendant solely to audition for him, but her contemporaneous text messages revealed that Jane was more interested in defendant for personal and romantic reasons. Oh my God, this is so beautiful. Let's read it again. Jane testified that she went to meet defendant solely to audition for him, but her contemporaneous text messages reveal that Jane was more interested in defendant was more interested in Kels for her personal and romantic reasons. That means that baby girl had an agenda.
And hey, hold on, Sky. If you go back to what you just read, now this is where it gets funky. Because see, they didn't tell us that in the courts. They did not say what's being said, what Bunjean is saying now. Bunjean is telling us what actually happened. They did not give us all of that. They cut some of that out. And I thought that's what she said, that she wanted, she wanted it. That's what she wanted. But they were trying to put it as though all on the mom, that she didn't really want that. It was just the mama pushing her on him. No.
But see, here lies the problem with the transcripts that these dummies keep on trying to hold so sacred like it's the Bible. All this information was not nowhere in the transcripts that they tried to covet so graciously. Okay, it wasn't there. And like you're saying, they're not gonna say any of this because they didn't want it to be anywhere.
All that about Becker was not in the transcript.
That's pitiful. Hold on, we finna finish reading this real quick. Jane texts her mother, he's so fine. Jane texts her mother, he's so fine. When Jane's mother told her to be ready to sing something, Jane said, ugh, suggesting that she did not actually want to audition for Kels. Jane's mother encouraged Jane to tease. Oh, listen to this. Jane's mother encouraged Jane to tease Kels, but not to do anything sexual with him since he would then lose interest in her. Believing, now see, that's old school game right there. And
that's Pimple game.
Yeah, and see, we know this right here for a fact. Because if y'all don't know it, y'all better get some male friends Once he get a taste of the cow, he about to run off. Okay, the challenge and the hunt is over. He about to go to the next pick.
He don't need it. He don't.
Okay.
What do he need you for?
That's right. He done bumped it. He done hit it. Now he can go on to the next one. So she's trying to say, maintain your worth. See, that's how I know this is true. Believing that he was speaking to an 18-year-old Jane, Kale's text Jane's mother that he was staying on the tour bus, but was going to get a hotel room for their privacy. Jane's mother then shared that message with Jane, texting, yep, he said he's staying on the tour bus to get a hotel room for just y'all, so y'all can get away from security.
Shut the front door. You know, girl, this was not in the transcript.
This right here, y'all. I don't want to hear nothing. Y'all ain't even saying. Y'all think I was deadly before off the hip. Y'all don't even want to see me after I read this whole thing and let it marinate. I promise you, y'all don't want to see me. I promise you. Jane's mother gave Jane some final advice before she sent her daughter to meet Kales, who believed Jane was 18 years old. Like we said, he thought she was 18, just like you guys are so caught up trying to make him, the girl like him, know she was 17. She lied. She admitted that she lied about her age. He thought that she was 18. Period, point blank. She's a liar.
And he was not 55.
There you go. And her mama sent her up and set her up for the kill. I shouldn't have used that word. I'll take that back. But her mom set her up to get put on the platter. Okay, let me see. Be prepared to sing 3 songs. Oh, wait. Girl, they done put the text message in here. Oh my God. When y'all listen to this, Kale supporters in the chat. Let me go back to see this chat real quick, because y'all not going to believe this. I'm sorry, I got this thing up there. Y'all not going to believe this. Let me scroll down. Y'all not going to believe this. Y'all is not going to believe this. They got the text message in here. If I missed anybody, hello. Wait, what was in the transcripts? And why you in the chat? Why you not in the panel? Before we get out of here.
Who is
this
that?
Is okay, wait, let me see what she say. This the kind of stuff Bojin was speaking of earlier in the motion, other things not in the record due to the fight between attorneys over not being able to speak about the parents. Okay, let me read that again. This is the kind of stuff Bojin was speaking of early in the motion, other things not in the record due to the fight between attorneys over not being able. Yes. Elvira, I stated that the parents should have been interviewed, and people try to tell me that was just some crazy thoughts. And you know, when the Kale supporters was screaming, "Where are the parents?" Yes. They acted like we were crazy and that we were so naive, and we, you know,
I went on Levi's channel to clear that up while we were saying where were the parents.
You did. Okay, Angie coming in here. Let me go ahead and finish reading this. Angie, well, let me let her in first. Once it say device is not connected. Hey, Courtney. Y'all put on y'all mute for a second. I'm about to read this real quick.
All right.
Okay, there we go, Angie. Okay, y'all mute real quick. Let me finish reading this, and then I'll be right back, and then I'm gonna let y'all chop it up.
Wait a minute.
Huh? Say what?
What I hit? Close the mic.
You said close. You got the mute? Yeah, there you go. Hey, the truth. I would like to know the parents. Yeah. Where was the truth? The parents were here. I don't know if you just came in, but the parents, the girl's mama, was texting Kales basically the whole time. Wait till Truth. Watch this, Truth. I'm about to read these text messages. Y'all listen up real quick. This is some crazy mess right here. Okay. Me. Defendant who believed Jane to be 18 years old. These are text messages right here. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best. Pretty hurts the and third. Hold on. This retarded talk. Hold on. Let me get Ebonic. Hold on, y'all. Okay. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best. Pretty hurts and third, your choice. Don't yell. Put on a show. Dance. Grab his hand. Shimmy. Wiggle. Sit on his lap, entice him while singing. It's all about performance. This your chance and opportunity. Don't blow it. Jane's mother even told Jane not to look grown. Emphasis at it. Double quotes around it. Take off that ugly ass lipstick. I told you he don't want you to be grown. I told you to keep hair curly. That shit look a mess. You need some jeans or shorts. You trying to look grown. He wanted you because you look young and innocent. That's what he want. Not a little girl trying to be grown. You're a damn fool. Woo! Defying her mother's advice to merely tease defendant, Jane engaged in sexual conduct with defendant in the hotel. Jane stripped down to her undergarments and walked back and forth for kills. She later acquiesced to removing her clothes, testifying that she got on top of him backwards and he did lick my butt. Yo, my stomach. After the sexual encounter, officers arrived at the hotel room and knocked on the door. After arranging for Jane to meet defendant in his hotel, Jane's parents apparently called the police. Y'all see how that's a scam? Well, hold on, let me keep reading. Okay, after arranging for Jane to meet defendant, that was a setup. They set him up right there. After arranging for Jane to meet defendant in his hotel, Jane's parents apparently called the police. Jane described defendant as nervous and anxious, asking her to confirm that she was 18 years old as she had represented. Jane testified at trial after Kales looked through the peephole. He made me go into the restroom immediately and told me to get dressed, and he said, "Are you 18?" I said yes, and he said, "Don't lie to me." I said yes. Defendant opened the door. The police checked Jane's identification to confirm her age before leaving. Defendant was present when police officers checked Jane's identification. Rather than calling it a night, Jane again removed her clothes and got on top of the defendant to continue their sexual activity. Now wait, let me go back because we missed something right here.
I want that, baby.
Okay, wait. Defendant opened the door. Although defense counsel sought to present evidence that Jane's parents intended to, here we go. Listen, y'all. Although defense counsel sought to present evidence that Jane's parents intended to set defendant up and extort him, the court precluded that testimony. Okay. And the police checked Jane's identification to confirm her age before leaving. But see, this is where I'm confused. If he checked her identification, they should have seen that she was 17.
She had a fake ID.
Wow. Okay, defendant was present when police officers checked Jane's identification. Rather than calling it a night, Jane removed her clothes and got on top of Kels and continued their sexual activity. After her first encounter with Kels, Jane told her mother that defendant had asked whether he could fly her to meet him. Jane told her mother, I said, duh. Jane continued to communicate with the defendant via text message and by phone and continued to spend time with the defendant in Orlando doing normal dating activities such as seeing movies and eating out. And guess what? All you people who hate Kels, all this was done under the mother's consent. The mother and Jane knew that she was 17 years old. Kels did not know that. The police came in, checked the ID, and clearly if it had to say that she was 18 because otherwise they'd have been up on them. Okay, so where were the parents is the correct thing that needed to be asked, because it's clearly right here she's working in concert with her daughter and they set Kels up. Why would you call the police on him after you know you approve for her to go there and be with him? Y'all see that? It's a dirty game, you guys.
What was the dates again, Skyye?
Let me see. At one point, Jane's mother got frustrated with Jane for not prioritizing her music with defendant on April 23rd, 2015. Jane's mother texted her April 23rd, 2015. Jane's mother texted her, you need to let him hear your songs. Let him see your video. You trying to date the man. You need to let him see your shit. Emphasis added. Oh, God. Jane's mother also continued to encourage Jane's relationship with defendant, telling her to be a little feisty, stating he married Aaliyah because she was feisty. This is sad.
Didn't we say that? They all trying to be Aaliyah. They wanted them to be another Aaliyah.
This is sad. This is sad. This poor child. This is sad. This is sad, you guys. He married Aaliyah because she was feisty and she didn't let him run over her. You need to be different than the rest. Later that evening, Jane's mother texted Jane, you are silly. That man ain't trying to do nothing with you musically. He want a FUCK, period, because he like young girls. Jane reassured the mother that the defendant was willing to look at her performances and was patiently waiting to look at some of her videos, and her mother had some of the videos that her mother had emailed her. So basically, here it go right here. The setup backfired. This is why the parents went bad. They set her up to go in there. They wanted her to entice them. The girl got there, saw Kels was fine, gave up the booty, and then she was done with the music at that point. She was in love with Kels. So, and it says right here, the parents, wait, I just read this. Okay. Jane's mother got frustrated with Jane for not prioritizing her music with the defendant. That's it right there. Let me give y'all the page number.
Her mama said she want to take care of her. She
said he want to get down. He want to hit the box, period. And she said Jane reassured her mother that the defendant was willing to look at her performances and was patiently waiting to look at some of her videos. Okay, on April 24th, 2015, after defendant had left Orlando, Jane's mother instructed Jane, you better be texting him so you will stay in his mind. Wow. Telling her 17-year-old minor baby daughter just out the womb, you better be texting him so you will stay in his mind. Later that day, Jane texted her mother about flying out to see defendant in California. Jane, I talked to R. Kelly. Hold on, let me see. Yeah, Mom. Yeah, about what? Jane, laugh my LMAO about flying me out. Oh, really? When? Mom, oh, really? When? Jane, yeah, whenever I tell him he can. Tomorrow if I choose. Mom, oh, yeah. On April 28th, 2015, Jane traveled to Los Angeles, California to meet Kels with the knowledge and consent of her parents. Let's read that again. On April 28th, 2015, Jane traveled to Los Angeles, California to meet Kels with the knowledge of her parents. Parents has an S on the end, so that means both parents. That means the father and the mother. Okay, let's read that again. On April 28, 2015, Jane traveled to Los Angeles, California to meet Kels with the knowledge and consent of her parents, plural, meaning mother and father. Jane continued to text her mother once in Los Angeles. At one point, her mother told her he going to be in your room butt naked with one of his songs playing, LOL. Government's Exhibit 233 reflects that Jane and her mother text incessantly while Jane was in Los Angeles with defendant. Wow. So that's letting you know right there, mother clearly knew what was going on, clearly knew where her daughter was. Reflects that Jane and her mother text incessantly. And you know I'm petty. Google, what does incessantly mean?
Here's the definition of incessantly. Without interruption, constantly.
Woo! Without interruption, constantly. Okay. Jane tells her mother at one point, crazy, this Aaliyah movie just came on and I just got off the phone with R. Mom responded, really crazy. Jane testified that she had oral sex with Kels in Los Angeles, but she did not share that information with her mother via text. At no point did Jane express any apprehensions about being with the defendant. At no point did Jane express any apprehensions about being with being with Kels, or ask her mother to arrange for her to come home. At no point did Jane express any apprehensions about being with Kels or ask her mother to arrange for her to come home. I want an apology. I want an apology from all y'all who doubted us Kels supporters and who doubted me when I told you guys these young girls was trying to give it up. They wanted to be there. It already said in this thing that she was there for her own personal gain and for her own. Oh my God, I want an apology. But y'all don't even got to give it, because this right here is justification enough. Let me keep reading and we're going to let y'all chat and then we get out of here. At no point did Jane express any apprehensions about being with the defendant or ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding Kels' tour bus to Stockton to attend his concert, Jane's mother responded, OMG, exciting. You riding on the tour bus? May 1st, 2015. Jane's mother urged Jane to take advantage of the defendant, texting her, it won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he tired of you, you'll be like everybody else. Ooh, she giving her game, y'all. You better use this as your opportunity while you got him in spell. She thinks that she got Kels P whooped. Jane's mother, and that's the problem. See, she gave her daughter poor game. You ain't never got him whooped. Then said you should text him. You should text him and be like, you know you're gonna be my boo, and see what he say. To which Jane responded, laugh, LMAOOO. This is her mother, you guys. This is not her friend. This is her mother she's texting, okay, and communicating with like this. Sad and pitiful. Jane traveled independently to meet defendant in Stockton, California, where he was performing on May 1st, 2015. She stayed in contact with her mother the entire time. At one point, Jane explained to her mother how she ended up going to Stockton to see defendant's performance. I told you, he asked me that I want to come to his show, and I said, of course, and he said, okay, then let's pack this stuff up. He was even putting his stuff in my bag. Jane and her mother remained in constant communication before defendant's show. Jane's mother instructed her about what to wear and make suggestions about how she should behave at the defendant's show, I would blow him little kisses and weaken him a bit. And bite the tip of my fingers. And bite the tip of my finger, mess with him real good. Do something seductive, then make a silly face. Laugh out loud. Woo! This is her mama telling her to do. My God, this is sad. Jane and her mother continued to text throughout the defendant's performance. At one point, Jane and her mother exchanged the following text. Jane, he's singing this whole song. He's singing this whole show to me. Mom, LOL, too funny. Jane, for real, FRRRRRR, basically for real. Jane, laugh, LMAOOO. Jane, this man in love. Mom, OMG, you're going to marry him and have his babies. Her 17-year-old minor baby, just out the womb, just born daughter. Mom says, OMG, you're going to marry him and have his babies. I want an apology. All of you guys that said, I swear to God, that we knew what we was talking about with these parents. Mom, LOL, my son-in-law gonna be older than me. Yeah, I ain't even gonna be able to sleep tonight. Mom, too dang funny. She actually said, my son-in-law gonna be older than me. If y'all don't get Kels up out of that jail, I'm not playing. I am not playing. This is so flawed and fool. Let me keep on reading. Get him up out of there. Not now, but right now. Mom, too dang funny. Jane, LMAOOO. They set him up. They set him up. Mom, well, you better get signed first, then marry second. Mom, he gonna seduce you tonight. Jane, LOL. Mom, you have to give him a message before he go to bed. Jane, LMAOOO. No, I doubt it. No, I doubt it. Mom, girl, you better, or he will get someone else to. Jane's mother. Wow. Oh, massage. I'm sorry for being illiterate and can't read. Mom told her you better give him a massage before he go to bed. If y'all don't get Kels up out of this jail, I swear to God. Jane, LMAOOO. No, I doubt it. Mom was like, girl, you better, or he will get someone else to. Jane's mother continued to encourage her to seduce Kels. At one point, Jane told her mother that she caught feelings for the defendant. According to Jane, she and the defendant had sexual intercourse for the first time after the concert. Now, Nisimo, you're going to have to give us the dates on that, okay? I can't remember what I wrote back, but after the concert, she said the first time they had sex was after this concert. Okay. At no point during her travels with defendant in California in April or May did Jane disclose that she was 17 years of age or that she had lied to him about her age. After the trip to California, Jane traveled to meet defendant in Las Vegas where he was performing. No rational jury could conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's contemporaneous conversations with her mother showed the defendant invited Jane to join him, and she excitedly accepted. Like we said, Kels is fine. Kels is a mega superstar. He don't have to rape nobody. He ain't got to beg nobody. He ain't got to put a gun in nobody's head to get down. She wanted to give it to him, and she gave it up. It says right here again, Jane to travel. Okay, wait. No rational jury could conclude that defendant enticed, persuaded, induced, or coerced Jane to travel to California. Jane's contemporaneous conversations with her mother show that defendant invited Jane to join him, and she excitedly accepted. When her mother asked her when he asked her to travel. Jane told her mother, whenever I tell him I can, tomorrow if I choose. By her own admission, Jane chose, they have this in italicized, meaning emphasis. Jane chose to travel with defendant because she wanted to, and her mother encouraged her. While this court concluded that Jane's parents' testimony was not relevant for the purpose, defense counsel sought to introduce it. Jane's text messages with her mother, introduced as government's Exhibit 233, were highly relevant evidence that defendant took no action to induce, persuade, and coerce Jane to travel with him. Jane was eager to travel with the defendant and caught feelings for him, and she admitted and concealed her age from defendant so she could pursue a relationship with him. The government's evidence fails to show that Jane was persuaded, induced, enticed, or coerced into traveling to California. My. And the other one under that is Mann Act. I'm going to let the panel go. Y'all, let's get it. Let's get it. Who want to go first? This is unbelievable. Unbelievable.
Hold on. Skyye, you're going to have to help me out, baby. You're going to have to help me. Because, wait a minute. Why am I getting a fever? Is that me?
I don't hear nothing right now.
Okay. All right. Skyye, you go from one time where you get it, we talk about, we get it, whatever. Then you go another, and then you act like you don't understand, and you tell me something I done said, I ain't said. It's just like I mean, when I tell you, you ain't nothing but Robert Keller to the 25th, the female version of Robert Keller. Y'all ain't gonna kill me tomorrow.
Look, I gotta be lengthy. Okay, so when I say what you said, I gotta go by sentence by sentence.
Wrong. No. Okay, check this out right here. Listen, and I'll go into this further tomorrow, right? Check this out right here. This is what she's trying to say is this stuff. The defense didn't get into this stuff or whatever, which would have been relevant. So she says would have been relevant with regards to the case, right? And I get that, what have you. But what you're saying is when you said that the parents consented to her being with R. Kelly, right? In that nature. A parent cannot consent to someone under the age of majority to have sex with anybody by law.
I understand what you are saying.
They will go to jail along with the person that they're having sex with.
Okay, there we go. Wait, stop right there. Because what I read is exactly what you said. What I just read is that they stated that the parents gave consent to her daughter being with her. And not only that, the daughter consented to being with him as well. So based on what you're saying is, since they can't consent legally, if Kels is locked up, they should be locked up too. Next point. Go ahead.
Right. And I just said that. Right. And that if the prosecutor decide to go after them, whatever, that is totally, totally right. Right. That's the correct.
Okay.
I ain't gonna sugarcoat it. All right. So we got that. So, and let me tell you why, other than the reasons, you talk about a lot of this stuff, if it wasn't admissible, because I was in and out. A lot of the stuff that you're reading about, the text messages and this, that, and the third, whatever, if it wasn't admissible, then it's not going to be in the transcript. So, that's not going to be the transcript. Now, you called at one point. You called her. I came in when you called her a lie. What part did you call her a lie on? Were you just called her a liar, or were you saying she perjured herself?
I don't even remember. Who was I talking about?
You was talking about Jane Doe number 5.
And I said she lied?
Yeah, because that's when I came back in.
She lied about her age. She didn't tell Kels that she was 18. The whole time that he was getting down with her, allegedly, she was telling her, the mom and her were telling him that she was 18. He never knew she was 17. That's what they stated.
Right. Okay. So, and I understand. I have to go into that a little bit. Why all of this is in here, and which this is and let me go on record and say this, and I said it on my channel, whatever. Now that you're reading even more, and I thank you for reading it, because I'm jotting down the parts that I need to communicate to everybody. This is a brilliant motion.
Brilliant.
I'm telling you, this is a brilliant motion.
Yes.
And this is only the first couple that she could file due to timely filing. It's some more that she got. Then she also has to look forward to the appeals. Let me tell you why. Y'all gonna have to, stop. I don't criticize any other attorney, but y'all gonna have to stop criticizing Canick, because they kind of set this up. Let me tell you why. And I'm going to more on my channel just by listening to what you read. All right. In his final motions, right? I said when we did the R. Kelly exercise, I said that the only way they're gonna only strategy that is possible to me would be an exculpatory defense, right? One that either justifies it or excuse it. When he put in that last motion, talking about mistake of fact with regards to the age, that was an exculpatory defense. Okay, see, follow where I'm going, because when your strategy, your defensive strategy, cannot contradict your appeal or your final paperwork. So he did a real good job in keeping that defensive strategy consistent to where it would go along with the post-conviction motions and the appeals. So it won't be no kind of a contradiction there.
Okay.
So what they're saying is, had all that information been included or whatever, admissible at court, what have you, that would have fallen in line with why he thought she was 18. That's why he was with her. Okay. That falls in line on what Canick was trying to do. He was trying to say this happened. The parents and stuff played a part with the enticement, the inducing, and all of that. That is what this lady is confirming. So he really gave her a layup, and all she's doing is bringing it home.
I got you.
This is a real good connection. So that's what I'm saying. So they're saying if this evidence was entered in, it could have made a difference. Now, if this evidence was, this is going to be really good. If this was a part of the evidence that Nicole was in charge of, that she had something to do with. Because now the lady's saying, because Nicole never should have been there because of the conflict.
Yep, because she was compromised.
Yeah, this evidence could have been in, this evidence could have been handled, but it wasn't, because she was unable to do her job as a defense counsel because of that conflict, because she remained on the case when the amendment said she should have never been on the case.
Yep. She was.
What I'm saying? I don't know why Kelly couldn't understand that. What I was trying to tell him, that forget that he waived his right to get rid of her as far as a counsel due to the conflict. That's just the trial portion of it. That what goes on at trial. That's one level. Above that, you got the answer to the amendments, the Constitution.
Yes, he could understand that though, Angie. And one thing I learned about Keller, he's not going to understand it online. Okay. Now, after he gets offline and takes a moment, then he'll be able to pull it together. But he was never going to be on that channel and let you tell him that he was wrong. That wasn't going to happen, and you know that.
Yeah. But honey, I'm just trying. He think he gonna. No, it take him a minute to get it. He's gonna take him a minute to get it tomorrow. But he think he gonna beat me down and have my brains
Right.
It's on the ground. Look here. I clicked the live and my brain on the my brain in the chat. That's what my brain at. You think you're gonna do me like that?
Right. I swear.
You think you're gonna do me like that? No, ma'am. No,
But I totally understand what you're saying.
You understand what I'm saying? If she was never on the case,
yep,
this evidence could have been in.
Yep.
And she's saying that it could have made a difference because she is arguing in her brief that this evidence is relevant, especially when you have the government saying that he induced her, he did this, when the evidence is clearly showing, I mean, in my opinion, let me say alleged, in my opinion, that it was the other way around with the assistance of a parent. This is earth-shattering. I'm about to go live again.
Because all I'm gonna do, Angie, is probably try and take me a nap, and then I'm gonna get up because I gotta read the rest of this because that right there like is blowing me away because they said that the mother was texting, but when you hear what she was texting, my God,
this is crazy. When I tell you, I'm glad. Shout out to everybody that's reading. Don't listen to nobody that said y'all want to say y'all shouldn't read this stuff, whatever. Because y'all saving me. First of all, y'all saved me a whole lot of work. All I just get a little error, and I can put it together legally. Where is she going with this?
Yeah,
this is off the chain, honey. I ain't go through it. I just went to the little parts where I was looking for what she was trying to prove, what she was trying to say. Now she got a whole situation with the parents, girl.
Yes, the mother and the stuff that the mother was saying to entice him. He don't want you because you look old, look young, and just the stuff. And just you, my son-in-law is gonna be older than me. Are you kidding me? Are you kidding me?
Wow, the Lord have mercy. When I go live tomorrow, y'all, I'm gonna kill the other half of Club Blue. my entire chat gonna be dead, y'all. They're gonna be I'm like anybody there?
I swear to God. Because I mean they about to be big man, Angie. Like this is insane. Wait, she said so this info couldn't come in because Nicole had this info, but she was divulged to the defense team.
We don't know. I don't know if Nicole had this info or you know what I'm saying because
we don't know where this came from.
If you read it, she's saying if you read the other part of it, when it was talking about Becker being ineffective, she was saying that the evidence that Becker had could not be used because she was because of the conflict of interest.
There you go.
This is evidence that wasn't in there.
Yep. Because if she did have it, and let me hope y'all getting them likes up. Let's do a moment of silence for them likes. But
lock her up.
Yeah, but she couldn't. He said she couldn't bring it out because she was compromised.
Wow.
That's really sad.
This is crazy.
Mm-hmm.
I can't believe this. And that lady is, that lady is saying, I'm trying to tell you so. Y'all gonna have to give the black brothers a little credit. Y'all gonna have to give them some credit. Because like I said that, he set up a good gateway for an appeal. And his strategy will go in line with an appeal. It's not going to contradict.
And see, I said that Koenig did the best he could with what he could have. However, they should have all been on the same team, working in concert to support him. It was too much dissension. Absolutely too much. Hey, Loanne, welcome to the chat.
Hey, Loanne.
Too much dissension.
Honey, I am on the ground. I'm getting bits and pieces from here and there and everywhere. I'm on the ground.
I want to read that part that you was reading over there. I got to see if I can get that because Alice knew the dirt. She did. That's why she stopped talking and let her pimp become the leader. But see, my God, you guys, all we needed was for her to have to testify. Do you understand little things like that? You know, but you got people on the sidelines trying to act like because people don't have legal degrees, they don't have common sense. Stevie Wonder could see that the parents was complicit in all of this. You know, all we knew was about the sex toys and the extortion for trying to get a job. We didn't know about, we heard about these text messages, but we didn't know what these text messages was saying.
Yeah,
You know, we didn't know.
yeah. I mean, this. I don't remember reading this, and I remember hearing about this in no darn text, in no transcript. Now, I mean, I think this is the stuff.
It wasn't in there, Angie. It wasn't in there.
This must be the stuff that Miss Jennifer saying that should have been in there because it would have been relevant to this goddamn case.
But like you said, if the now look here I go. Like you said, let me go.
Lord. Here we go with like you said. Oh my God.
Okay, let me see. Okay, so they tried to get it in, but the judge said if you open up that door, then that means the defense is gonna be able to say something. I hope I said it right.
The prosecutor, like, so either side. So when the defense open up the door with a line of questioning or evidence like this, that means the prosecutor get to say something, and vice versa. So, but I think what she was trying to warn against is like you putting the parents up there, so you automatically giving the optics that somebody is a minor, and and then it's gonna be. Then and I think they only restricted it to what they were going to ask about. Wasn't about mental health or something like that.
Yep. They didn't want to say nothing about mental health. Yep.
Right. So they didn't even bring it. So she could say that this falling upon the ineffective.
This falls under. Hold on, let me see.
Yes.
And Courtney, you have to be up next, Courtney. Give me 1 second. Let me go to this other page, and then I'm gonna let you speak.
Scroll up to the bold. Bold.
Yeah, because it was like part 1 and part 2. Okay, I know this was under racketeering. So hold on, I'm still going up, page 35. Okay, here we go. This is under Racketeering Act B. I'm sorry, Act 8B.
Coercion. General argument. Scroll up.
Okay.
She says should be big print.
Oh, it was saying 1 and 2. How about this? Violation of health. Not
the little one. It's gonna be big. It's gonna be bigger than that.
Let me see. It was like a big paragraph.
I wonder if this is this up under the ineffective. Let me see.
Racketeering Act 6. No, that was Geronda. It just had it under the racketeering.
No, just scroll up because it'll tell me you're running to it. It should run to it. It should be a heading. It should be as a heading.
Let's see. It did have like a little break. Is that it right there? Let me see.
Keep scrolling up. It should tell
government failed to prove that so-called enterprise activities affected interstate commerce.
Go.
Keep going. Okay. Looking for a bigger head.
Yeah.
Five.
Wait a minute. Scroll down a little bit.
Okay. Right there.
Wait a minute. Go back up.
Government failed to prove defendant guilty of the offense of racketeering. Count 1.
Count 1. Scroll up a little bit. Let me make sure that's where the biggest heading at. Because it's going to tell me something.
Then it says argument and relevant facts.
Keep going up. Scrolling up.
Introduction. And then the index.
Okay. What's the heading of this whole brief? What is this?
This is the
okay. All right. So is she attacking the RICO?
Yes. It's multiple things that she's attacking RICO.
Okay. She's coming at all angles. Okay. So now she's attacking the RICO.
Uh-huh.
She's trying to knock the charges, the predicate acts from up under there.
Okay. Okay.
Okay, so if she is asking, so if is this scroll all the way up a little bit. I'm sorry. Is this a new trial? Is this a motion for new trial?
This is a quit. No, this is a quit. I read the new trial earlier.
Okay, this is a quit. Okay,
Yeah.
good. This is a quit. Okay, because she put in a quit and a motion and a new trial motion, because if the acquittal gets granted, and because y'all have to do all of this within filed within the reasonable amount of time, before the time elapsed, right? So
Okay.
if the acquittal goes through, there's a new motion already in, okay? And if at a later date, if that gets reversed or vacated or something like that, then a motion for a new trial is already in place, and it will be filed on time. So she's not missing anything. She's taking
Okay.
real good care of him. I don't know who brought her in, but that was a smart move.
That was very smart. Oh, okay, and 1 second. Let me
Bill Cosby.
Okay, go ahead, Courtney. Oh, Bill Cosby brought her in?
Yeah, don't y'all remember on TMZ when the representative that the spokesperson or the PR person for Bill stated that she was gonna take R. Kelly's case? That was on TMZ.
Oh wow.
That was on
I didn't know that.
It had something to do with it, with him coming.
Yeah, that was on that, because that's why I kept on saying in the chat, shout out to Bill.
Okay. Okay.
And just for a lay person, of us that's been following this, dang, I lost. Hold on, I'm so elated.
This is crazy. This is pretty good,
because we got the we got to fight the feds at all costs. And if you like, I'm listening, if you look at that, it sounds like somebody else behind the scenes been following this just like us. And there had to be Bill. See, because the way this lady did this, and remember when she got on the on that news channel, and she stated why she picked this case up. She said it clear as day that she believed that this man was innocent. She said, I mean, it didn't even take rocket science to even know that that's what she was saying when they interviewed her on one of those on that news station. HLN, is that the name of it?
SNL, Saturday Night Live. Is that what you're talking about?
No.
Oh, it's okay. When the trial was going on, and remember, we already knew that it was closed off, and we knew that they wasn't bringing the right information to the public. Well, it was that one, they something like Court TV, they was in there too, and they was the one bringing us what was really going on. Because don't you remember when the Kell supporters was up there telling us, they not telling y'all what's really going on in there. They not telling y'all what's really going on in there. They something like BCB network. Something like
BNC?
They something like that. I think it's HLN.
Oh, okay, HLN. Okay, I know. Okay.
Yeah. They was in, because don't you remember when all we was following it closely. Remember when they was saying they not coming telling y'all what's really going on in there.
Yeah, it's a lot that we didn't know about.
Yeah, it was a lot that we didn't go.
Wow.
But my thing is everything that you reading, you've been saying. We've been saying that.
We've been saying it.
See, because we looking at this, okay. I'm so full, because I rocks with Skyye. I want to say I know how Skyye run her channel. I want to say hi to everybody in the chat. we from the streets. We know how this go.
We know how it go.
We know how this go. So we've been, and I don't know if you want me to mention. I'm not mentioning anybody's names, but
No names.
no names. But you have allowed other ops in your chat. We battled them out about a year ago. How long ago that was? We battled Cove. That's the only name. I ain't calling no other names. But we knew we knew the daddy. He kept saying in her music and her he if you listen to every interview that he ever did, it from when he sat up there with that man and that lady, when the mama got up there with the bebop hat on, you could tell that Angelo was trying to protect his wife from day one.
Yeah.
He was trying to protect, because he knew. He didn't know all of what they did, because he said, because when I found out, some people got to go back and they got to listen to Angelo and them, and I couldn't believe that these people was that them two was getting up on national TV and interviewing.
She said, put up the Cash App. Okay, the Cash App is up there. Hashtag Skyye Lyfe.
Yeah,
spaces. SKYYELYFE. Okay, go ahead, Courtney.
Yeah, but I just want to say, by them put by what you just read, he sat up there and told you that.
Yeah.
He sat up there as clean, as pure as day when he was Team Truth. He sat up there and told you what they did.
And it's sad.
If you couldn't peep game through that, then all of y'all old Skyye Lyfe over there battling.
Yep.
They're battling. Her and I want to clear that up for the new people in the chat. What she's saying, y'all owe me an apology. She's not talking about the people who y'all think she is. Skyye Lyfe talking about the people that she was battling 2 years ago.
Yep.
See, you've been battling them over there 3 years ago on the other channels.
Yeah, and not even coming from no legal perspective, coming just off the hip with common sense. Seeing how this stuff is going down. You see what I'm saying? Like, most of this stuff is not rocket science. Now, there's definitely a time for legal where certain things have to be done in certain order, but we saw that these girls, what they was about. We knew Kels is a mega superstar, and like she said, he's so fine. He fine. He don't have to beg no female to get out. Like, stop it. You gotta make him not a predator. A predator, they gave it up. Now y'all don't like my delivery, but guess what? My delivery is what it is for a purpose, to shake you up. Okay? I know how to say it smoothly and sweet.
And he wrapped
all that.
And like you brought it from the Chicago perspective. You took us on a tour. A lot of people didn't see your video. They need to go back. And you took us everywhere. He was touchable. They made it seem like this man was untouchable.
No.
You took us, Kels used to be here. This boy Kels he repped his city, and anytime you look at him, he had Chicago on.
Yes.
So that's the perspective for the newer people that's coming in and following Skyye Lyfe. She gave us a Chicago's perspective, just like the other people. I'm from Baltimore. Well, we trying to tell you, this man, even though he was a mega star, he repped his city. He was touchable. And that's the way you presented him to us. You gave us a better look at Chicago, because I'm gonna be honest with you, I always thought the man was innocent. But when you do have those periods of doubt, now what happened?
Yep.
Don't you actually think, because Chicago and Detroit, we twin cities, but our culture is a little bit different when it comes to pimps up, hoes down.
Right.
You see what I'm saying?
Right.
Y'all straight pimping. We were straight player. So that's the perspective of some of us where we was coming from when we was looking at this thing without blinders on. Because Ray Charles could see that this man, they didn't even bring out any kids. No kids. No, I mean, oh, they got 5-year-olds, they got 10-year-olds.
Mm-hmm.
Don't you think, just using your common sense, that the feds would have brought all of that out in the federal case? Oh no, they waiting on Chicago. What you gotta wait for Chicago for? Where are the kids?
Mm-hmm.
There were no kids involved in this at all. So I'm glad you let me come on. I'm a little all over the place,
No,
but
you fine. I'm glad you came up there. You fine?
because I'm one that this really truly changed my life personally, because I fought for kills at work. And this was like a
Mhm.
politic to me.
Yes.
This was like a politic to me, and I had an opinion. I'd be at work, free kills. I'd be at work bumping kills to get people to see where they got, like, who it was. Somebody in the chat earlier, and they was like, public opinion. They made the whole public think that this man was molesting children.
Yeah. Yeah. And
Well,
he's a predator.
that
See,
he was a predator.
that's the word that they don't understand. Predator is you going after. How are
Mhm.
you going after when they're coming to? That has been my whole argument the whole time. He's not chasing them. They're coming to him.
But now, we had some distractions. Cause see, when you in these YouTube streets, everybody gonna come up in your feed.
Mm-hmm.
Now you got to remember, let's go back on when we talked about the RICO. Do you understand, or do you actually think a 19-year-old daydreamed about, I'm going to become a superstar so I can fund and bankroll an enterprise, get up and sing so I can lure young girls into my bed? And that's the way they wrote the indictment.
Thank you.
It didn't even take rocket science to see that.
And it sounds stupid. You
And
see
it
what I'm
sounds stupid. And he became so that means to tell me that, the I mean, man, oh, come on, somebody take over. Come on, Sky, help me out. I mean, it was just the way that they were out, because I printed out the very first indictment. And when I read that, I was like, well, where how, where's the logic in this? And then another thing I want to say too is that me following, you never really heard, um other than the blogger or whoever's channel it was, you would always hear them say why they got into the fight. You never really heard a real subscriber say why they got into the fight. So when I would tell people why I got into the fight, I would have to knuckle it down. This is when I first used to go on people's channel, and they would tell me I'm inserting myself into it. But I like to take the time and appreciate this platform to say why I got into this fight, because I've been through that. My son was falsely accused of molesting a girl, and I knew the process. My son had the right to see the discovery. He had the right to see, to say, read and know who his accuser was. And when we read the discovery, see, I never got a chance to see R. Kelly's discovery. I got it. My son, you know, and all charges was dropped. That's one of the reasons why I got in this, because I had just went through my son being falsely accused of that. And my son from day one always say, Mama, you could say what happened. And it was like maybe 3 years ago, I had got up on the opposite channel, and they was trying to tell me that I was wrong about why I got into this fight. And I got in the fight for the injustice and the lies that people tell. And it's a whole lot of women out there, and it's a whole lot of people that do that. And what came out in court is that my son broke up with his girlfriend, and his girlfriend and her mother coerced her into saying those things.
Mm-hmm.
You,
So you were fresh off of knowing
I,
going through this.
yeah, yeah, and
Wow.
I could say I spent 10,000
Woo,
on
baby.
10,000,
Baby.
and my son,
Wow.
he used to want me, but they wouldn't, I didn't get a chance, to get in there, because they was over there debating this and that. And my son, he was like, Mama, they ain't gonna see. But it could have got to the point to where I was gonna, but I saw how people was getting doxxed, and people's addresses was being put up there. And this was like what, four, going on 4 years ago. And I was willing to allow, my son was willing to disclose some of his discovery on how the lies were just all over the place. And the girl said that my son, she didn't come forward until she was 17. And she stated that my son had been molesting her. And I don't care if this recorded, because I done said this story before some years ago, if anybody remembers me, that he had been molesting her ever since she was in the 5th grade. But she said that it happened while everybody was at home asleep. And the lawyer that I had, she told me, I'm going to go after the parent.
Mm,
And that's facts.
that part.
That part. Because I was like, how you going to do this? She said, we ain't even there yet. My son's case didn't even get bonded over to what we call Frank Murphy. It stayed in a lower court. And she was filing motion after motion after motion. My son was in jail on $1 million bond. And this is real talk. So
Oh,
if anybody want to come up here and like them other ones, I was held captive, I was bonded up, I've been through this. And that's why
wow.
this fight. And this happened in 2018.
Mm.
So
Wow.
I appreciate you, allowing me to go back, and this changed lives. And I want to shout out to our, if you don't mind, R. Kelly's children.
Oh, absolutely. That's
Our
that's more than
children.
fine. And
All
I'm
this
glad you're sharing your personal perspective, because a lot of people don't know why people get, end up on which side of this here thing. Everybody has their own reasons and justifications, but I'm glad you shared that with me, because that helps me better understand you too.
Oh yeah, oh yeah. And like I said, not to. I just want shout out to his children, because I was so embarrassed to tell my job that I needed time off to get my mind together. I was so scared for my child. I said, "Do you got your paperwork?" He said, "Mama, they think I'm in here on felonious assault." So I already know the visiting, the touching through the you know, going to the courtroom with your hands and your feet shackled,
Mm,
and your lawyer saying, "Can you release my client?" No, they don't take those handcuffs off.
Mm.
They had to stand there. It's humiliating, especially if a person got people like us believing in him.
wow.
We believed, you know what I'm saying? This is
Yes.
body tonight, because this is the midnight hour for real. This is 6:18 my time, Detroit time. Shout out to Chicago.
Stand up.
And that's facts. That's facts. I put that. I wanted you to play that song. That's facts. See, because this is the culture that we live in. And then everybody was coming with, who I ain't know. Man, this is some gutter ratchet stuff that happened to this man. And no matter what that man did personally, this is just my opinion. In his sex life, you know where was the crime in that? To me personally, they didn't show me no crime.
No.
Where no crime was really actually committed. Was he morally wrong? You know, some people had to beg to differ, but that's for that man to answer to. But criminally, I didn't see where he molested no children.
Right. And we just went through Jane. What's she Jane number 5? I can't remember, but
Tell your people to get that spam.
it's a spam in there.
And how you
Yeah,
doing?
welcome.
Hey, y'all knock
Hey,
this.
I'm fine. How you doing,
Yeah.
Miss Courtney?
Yeah, I'm doing good. I didn't mean to take up y'all time, but I
Oh no,
just
that's
feel
okay.
great. You know, I feel like this is a win. You know, and maybe God had to set some of us, you know, down for a minute. You know,
Absolutely.
so we can see, you know, what's going on, because you can't always ride high off the hog. But I just wanted to come, you know, from another perspective of just knowing that we really cared about the man, psychosocial well-being in there. I don't know, but I've been to the prison. I don't know about no. I've been where you got to go and see somebody, and where somebody is looking you in your eyes and asking you, telling you, I didn't do this, like he was on Gail King. I didn't do this. I mean, you can see I
Right.
beat
He
on
was
this chest
adamant about it.
on God. I didn't
Adamant.
do this. I didn't do these things.
And did you hear him say, "Quit playing with me"?
He said,
That's another Chicago term. You know, that's what we say. We
yeah,
don't say "quit playing with me," you know, but we use that in different contexts. But if you listen to his lingo, Kels is Chicago, you guys. You
yeah,
know,
yeah.
he's Chicago.
Oh man, I looked at that Gail King interview about. I never saw the you know what, all this I'm talking, I never looked at the Lifetime.
Girl,
It
you
didn't even
don't even want to see it.
take for. I didn't look at that. I didn't watch that.
But you know what? I might actually go back and look at it, because I'm gonna tell you,
Did you watch it?
I watched some of them.
I didn't. I just
I couldn't hardly muster
uh-huh.
the fakeness, because I ain't gonna lie to you, the sound effects, the theatrics, the picture, I mean, the performance, A+.
But if y'all go dig in the archives, what's the one that had the real seductive voice? She the one wrote the book. What was her name? The one that wrote the book, Daddy's Little Freak.
Oh, the one girl, I don't want to say her name, but
Yeah, Cass Jones. Cass
Mhm.
Jones said that when they was at the shooting of the Lifetime, Andrea Kelly and the one girl who stole the tape and was extorting the man for the money, they said that they had to shut production down because them two was arguing on who was lying. She said that.
yeah, well, even Tim Savage said that he knew that they was lying. You know,
They was
people,
lying.
they knew, but you know, you got some people that want to take anything they can and use it as credibility. They knew this docu-series, because think about it. Let's just understand, if Kels was in his right status economically, they wouldn't have never got that off, okay? Because money would have stopped that production from even coming out, okay? You
Right.
tied the man's money up. You had him so he couldn't even fight anything legally. You know, think about all the cases that came down before him. The studio came down. All these people coming down. Money stops all of that. Okay, so they set him up, man. It was a dirty game.
Yeah, and then you know, just you know, like when you be conversing with people and you know and listening to people, well, what the hell is all the fighting for about who paying for the lawyer? He paying for his own lawyer.
I mean, look.
Somebody getting paid. I mean, you see what I mean? I ain't going nowhere with this, but this man, do you actually you actually think that this man really care about all of that? That man want out of there.
He wants freedom. But anybody with some sense
With some
would
sense.
take it pro bono, because once Kels gets free, it takes one album and he back on.
Boom.
Okay? You better believe it. I don't care how many people hated him. This next album that he come out with is gonna be a #1 stunner. Okay,
it's gonna be. I remember the first time I heard, and then just to I'm glad you giving us an opportunity to just talk and just. I'm from Detroit, and when Aaliyah first came out, she repped our city hard. We didn't hear nothing like that. You know how you say, well, what did y'all hear in Chicago about R. Kelly? I mean, I'm quite sure y'all wasn't letting this man walk around do all that. We didn't hear nothing like that.
Right.
We didn't hear nothing like that. When she did Age Ain't Nothing But a Number, she shot all them videos here. We knew she was being backed by R. Kelly, but it wasn't like that's Aaliyah. She go to the Detroit School of Performing Arts. R. Kelly, that's her man. Wasn't none of that being said on my side of town. We didn't see none of that. So I just want to give you the perspective of, what I heard and what I saw. And she blew up like nitroglycerin, and we was proud and we was happy because we used to call her Detroit's own baby girl.
Mm-hmm.
She blew up like nitroglycerin. She graduated from Detroit School of Performing Arts. It wasn't like a rumor mill or anything like that going around. It wasn't nothing like that going around. We were shocked and appalled when BET or whoever broke that story back in the early 2000s, late 90s. We didn't even believe none of that. We didn't believe none of that.
Well, so that's good because it's a bunch of crap.
We ain't believe none of that. And I don't believe it now. I believe all of that is lies.
Yeah, because I mean they the whole thing, it's so many webs and the ways that they took us down.
My daddy used to say, "Woe the wicked web we weave, first to deceive."
Yep.
And that's real talk. So I just say free the king, and I'm gonna be quiet. I like listening to you, Miss Angie. I like listening to you. I be in your books. I see how you get down.
I'm sorry. Baby, they be asking for it.
I be in the bushes because we was battling it out, and I don't have nothing to say. Because I'll be listening. I don't have nothing to say because this was a battle to just fight the feds. That's what I kept saying. I kept saying we got to fight the feds at all costs. Because if anybody ever see me in the chat, I'll be saying R. Kelly got to fight the federal government at all costs. This just had me just so shocked and appalled. I just couldn't believe. And then y'all see the interview with the girl. The girl said she did not want to testify in the Chicago case.
Yeah, we saw that.
Yeah.
And that's my whole thing with this whole thing. And that's what I really, because we gon' because it's going on 4 hours. So we got about 8 minutes and we're gonna close out. But my thing is this, even if there is a mistrial, good luck. Okay? Because do you really? Because guess what? She done set the precipice that these parents need to come on in here and sit down. And we didn't even read Geronda's part.
Right. But I got a question for Miss Walker. This is my last question. I know we got to get out of here. Now, don't it take for one of them to say that they made one? Okay, Jane Doe number 5. Can it take? How can I add? Can she come forward and say that the federal government made her do that, and would they drop the charges?
they can say they pressured her
Oh,
to testify, but here's the thing, right? She also submitted some evidence. And they really, and here's the thing, with the government, they bring charges on behalf of the government and not behalf of a accuser.
oh,
So,
okay,
you
okay.
know, so really, technically, they really didn't need to. They really didn't need any accusers. But it's better for the case if they have all of them testifying and offering up, additional evidence. Now, you know, what will happen is if they say, they made her testify this and the third, then they can, petition the court to, have her testimony, impeached or whatever, all a
Oh,
part
I
of
get
it.
that was the part that confused me when they kept
Mm.
saying that word impeached. I kept trying to figure out, what they meant by that. Oh, okay, I see what you're saying. Yeah,
Mm-hmm.
but
Meaning
I'm
just get rid of some of it, like tell the jury, they'll strike it from the record, all a part of it. Tell the jury, to disregard. Well, they would have if they caught it during the trial. Tell them to disregard it.
oh, I see,
Mm-hmm.
because I didn't understand that, but this we still in the long haul for Kels. We still in the long.
Yes, we are.
Mm, mm, mm.
But I'm gonna say this: if she denies both of these, we already see what's going on. We already see,
Mm,
but guess what? It's not gonna be over. Cause
no,
Longine gonna take it to where it needs to go.
yeah,
Now, you got
yeah, but
one thing. I'm gonna keep it fair, whatever. That part when she was talking about inducing and things of that nature, I'm gonna think about it. But the only thing I can see the prosecution coming back with saying, well, you cannot, because she was a minor, you
mhm,
cannot, she wouldn't be able to induce. But
mhm,
Bonjean can still argue if the prosecutor prove that
mhm,
he induced or whatever. That may be an issue because we have to
mhm,
go back and look. Well, what did they use to say he induced her? What was the
Mhm.
evidence?
okay,
Mhm.
I see.
So Bonjean must have a challenge, a strong challenge to that evidence the prosecutor used if she raising this issue.
She came for the Mann Act too, Angie. Were you on here when I read that?
Uh-uh.
She came for
Yeah,
everything.
she knocked the
Every
Mann Act down too.
she
She stated that with
saying that.
was that Jane Doe or was it Geronda? I think earlier I read something about Geronda. No, that was Jane Doe with the Mann Act. Basically, hold on, let me see something.
Basically, it sounds like what you read to me that she strategically attacked Jane Doe's testimony.
Oh yeah,
Strategic.
Mm-hmm.
because she came in and said basically they didn't meet the fact
Mm-hmm.
that he that they had the understanding of having any type of sexual activity or him giving her. Okay, here you go right here.
Mm-hmm.
Because there's no link connected defendant's transport. Oh, this is for faith. Doggone it. But it looks like it looks like each one of them, Angie, they go through and they knocking off Mann Act right here for faith. They going down the line, baby.
Okay.
They come, oh Lord, they got Dominique name in here. The government argued that the defendant had directed Dominique to have sexual intercourse with Alex. Oh baby, they getting the details up in here. I don't even know who Alex is.
That's the kind of lawyer I had.
Well, they were breaking it down.
She every time we went to court, she came with a motion, and she was she didn't win the first motion that she won was for them to produce the accuser's school records. Did she tell the teachers that this had been happening for 5 years? She was winning motions, and the last one, and then every time we went to court, she filed the motion to reduce that bond to let him out until she
Okay.
got him out. It took her three
Mm.
times to get him out. it took her. They denied that motion, and the third time they reduced that bond to make it affordable for me to get them out. So altogether, I spent $17,000.
Woo,
And
baby.
didn't put my
Wow.
up. Quit playing with me.
That's why I
Wow.
try and tell people they go around these YouTube streets playing about a court case. You don't want none.
You
You
don't
don't
want
even
none.
want none.
I was working hooker
I
quick to,
promise you. Yeah, you don't want it.
and I mean I was working, and then I like they say, you will see who your real enemies and your friends are. And I saw who rocked with me, and I saw who threw my son and threw me by the wayside, because I was holding it in. I didn't know who to tell. I didn't even know until just God just said, just stand, just speak. And when I spoke, my neighbor, the one, told me, oh, I know a lawyer, because they was all trying to get me to get drug lawyers that fought drug cases. The lawyer that I had, she specifically was a criminal defense lawyer for sexual molestation cases. And she told me, she said, it would be unethical of me to tell you that I'm going to win this case. She said, but I'm going to go down fighting.
There you go. That's right. That's all she could do is do her best.
But wait a minute, one more thing. She told me how much it was going to cost. She said, but you don't give me everything up front. You give me something every time I had a retainer.
Right.
She
Retainer.
said, I had to I just don't take. She said, I'm not going to take your money like that. And I went in pieces, because some people were saying, oh, I want $25,000 now, and I was like, what? And then yeah. So I just, and what I'm saying is nothing that my son ever said that I couldn't say, because I used to say, I'm on somebody. Everybody in my household screamed, free R. Kelly.
That's right.
I mean, because I was going to throw him up out of here.
That's right.
Because my son used to be listening to me, and he was like, Mom, you done got sucked in. Like a lot of people, they don't, get up here and say, I done heard people say, you'd be surprised how many people this done probably disturbed some people's households. Come on now.
Oh, I'm one of them. Because I don't lie. It done broke up friendships.
Yeah.
All type of stuff, know.
Yeah.
And I've never been a fan of Kells. You see what I'm saying? When I grew up, I was New Edition, Bobby Brown, Johnny Gill. You feel me? You couldn't tell me nothing about them. Kells I was never a fan of him. I always loved his music, but I think the fact that he was touchable, kind of like, I don't know. I don't know. I never had that fantasy of him. Now, he's always been fine to me, but I think the fact that he was touchable kind of threw me off. But you know how you had I wish I seen Ralph Tresvant. I wish I, what I'm saying?
Oh, Lord, girl, I know you were. I got New Edition stories, honey. Oh, Lord.
Yes.
Well, I got some R. Kelly stories. He came to the Fox at the same time, and him and Charlie Wilson, they all, I bet you they say that at every city, but he used to say, I love coming to Detroit. Detroit is my second home. I done been up on the stage. I know how concerts go. I done try to get backstage. I know how that is, but I just can't imagine a man getting up there sweating, probably got the goggle, his mouth out with Listerine, and then he going backstage. Well, how many girls did you get me? Did you get me 5 or 6? I mean, that's what that was the narrative that was going on through my mind. Through that, the way they wrote that indictment, that he had bus drivers, runners, sprinters, they had 50, they was shitting in buckets, and they didn't want to get off. Well, shit, if I was with R. Kelly and he was in
cuss words.
Oh, okay. I was just trying to, I was like, well,
well, see, look, this is the thing. And this is why they messed up, because even after reading bits and pieces of this, they haven't established the enterprise. But you can't establish the enterprise when you done came in and took them all on the prosecution side. You see what I'm saying? If you'd have came in and indicted every single body, that's your enterprise. That's Kel's co-defendants. You see what I'm saying? But you came in to swoop them in to make them witnesses on your behalf. You see that backfired on them?
Right. There not yep. I couldn't have said it no better myself. Yep. That's
backfire. Yep. And that's why I can't wait to go through this with a fine-tooth comb, because I skipped over the part where it talked about the enterprise, but we're gonna definitely talk about that. But you all go ahead and give your closing, because we don't been on here almost too long. It's what, 5:39 where I'm at.
Well, I'm just that you let me talk, and I'm grateful to meet you, Miss Angie.
Oh, no problem. Likewise. Thank you, Miss Courtney.
Mm-hmm. All right, so thanks, Courtney, for coming in.
All right, love bug.
Okay, take care. Right. And thank you for the kind words.
Yes, man. That was nice.
Angie, did you have something that you want to say? Because I was reading through this while y'all was talking. I was like, ooh.
Yeah, not nothing, because I covered some, not too long ago, and I'll do some more tomorrow. But I was happy that I was able to get out the reasons why they can file a post conviction motion or appeals or whatever. But with some of this, I can see the prosecutor. They will have a comeback with some of it. I can see that, because they'll probably say she can't induce, entice if she's a minor. So I can see them come back with that. But with this is going back in front of the
wait, say that again, Angie. Say that again.
I said we're talking about the age.
You said something about they could come back and say what?
Well, they can come back. Okay, well, she's saying that the government did not prove that he induced, enticed, or whatever, based on, the text messages and stuff like that she used to support her argument in that brief, right? You just read, right? So, and that's fine, because it goes along, and in the bigger picture, which is good for the defense, is that it goes along with the exculpatory defense that they were trying to use. Now, it does not, with an exculpatory defense, it does not completely exonerate R. Kelly, but it mitigates his negligence, right? Whether because he's guilty. They're saying that he's guilty, but here's why. He's not guilty because he just just went out and this, that, and the third. I'm kind of paraphrasing, but they're saying he's guilty because somebody tricked him with an ID, and all these other set of circumstances happened. The mama was texting as her. He didn't, he don't have a ID machine running around to see how old someone is or whatever. He all he could do is he check an ID, check that if the ID is fake. How are he supposed to know? So,
but their main point was saying that there was no coercion, there was no predatory act. They were, the mother and the daughter were willing participants in whatever they was doing with Kels. Short and sweet.
Right. So if there was no coercion and stuff like that, then they're saying that the government did not prove that particular element. So correct. We don't have to. So what we would have to see is what did they use to say that prove that R. Kelly enticed or whatever whatever they say.
I think they just said it. I don't even think they provided no evidence, but like you're saying, we'll be getting into that. But I think it was just something that was said, because there was no. Because the thing is, they were allowed to scoot around that because the parents didn't have to come in. That all that stuff was shut out, so they could say whatever they want because it isn't. It hasn't been refuted. How do we refute it?
Right. You're right.
It's crazy. This is nice. And let me see what this saying, Angie. It's saying, lastly, the party's stipulation that the film used in VHS tapes was the type of film that was not introduced to Illinois is insufficient to prove by a reasonable doubt that the conduct was recorded on a device that made in foreign country or affected interstate commerce. Hold on, I got to go back a paragraph, y'all. And I promise y'all, I'm not going to read this. It just caught my eye. Furthermore, the government failed to prove that defendant acted with the purpose of producing a visual depiction of that conduct. What are they talking about?
They're talking about
Stephanie. Stephanie admitted the defendant called her on the phone and told her that he was picking her up and that he wanted to make a video of us having sex and that he would be there shortly. Okay, well, I don't even want to talk about her tonight. Okay, it's something with Stephanie recording her having sex. So they really going into this here thing, Angie.
Yeah, she going into it. She broke. I mean, she is picking a piece, and where Greenberg, he just sought to just try to get the RICO tossed out. Baronaire sought to try to break certain parts of it to dismantle it. She's looked like she's going for the whole thing, because with the RICO, you had to have 2 predicate acts within 10 years. So you have to keep that in mind.
Okay.
2 predicate acts in 10 years.
And see, they stated that they brought that up also earlier. It's something about they didn't meet the time frame of the continuation. Like I went through and read the index, and that was one of the things they stated in the index. So like you saying, they breaking this here thing down. They going knocking it step by step. Right. I really think. Now, I don't think Ann Donnelly is a righteous person. This is just me, y'all. I'm not being a hater. I just think she's a hater. I don't see her giving him an acquittal, but I see her giving him a new trial. But I really think good luck with that. We're going to pray for that acquittal, though. But I feel like she's an honorary woman, and I feel like she doesn't want to look like she did her thing wrong. Because to me, if she gives an acquittal, ain't that going to look like she didn't judge the case properly?
Well, no, it's going to look like it's going to probably lean more on the jury, saying that the jury, with all these factors that happened, the jury probably couldn't have not made a fair decision. You know what I'm saying? With all this extra stuff going on, stuff they didn't know, stuff they should have known, and the lady shouldn't have been on the case, and all of this here. With all of that going, with all that together, probably means that the jury wouldn't have made a informed decision. So it always also really rests on if the case was sufficient enough for the jury to make a decision on a verdict, either guilty or not guilty. So
okay,
yeah.
Well, maybe she will give us an acquittal. I'm gonna speak. What do they say? Speak it into existence. You guys, we going for the acquittal. I just think Ann is a hater, but
I think she did good, child. I think she did good. You so crazy telling the lady's a hater.
I mean, this is my thing, and I ain't gonna belabor the point because we're gonna be quick and get out of here. But just the fact that how I feel like they lied. I feel like she should have let the parents have to testify. I just don't feel like she was opening the door for the defense to get off. I feel like she was, every time they had opportunity, I feel like she was just knocking it down and just, I don't know. I don't feel like she was in support of Kale's, long story short. So, but Andy, if you want to go ahead and give,
of course she wasn't a supporter. I think she was just being fair. Right?
No, I don't saying ain't gonna give her a fair. We gonna let me read through this, and then I will answer that question. Let me read through this and see what they say, and then I'm going to. Oh my God! Look at this, child. It say right here, VIP room. He instructed her to perform oral sex on him. Geronda complied with the instruction. Geronda did not testify that defendant threatened her, forced her, or even demanded her to give him oral sex. Geronda did not claim that she feared defendant would assault her again if she declined the request. Geronda then left defendant's home and never came back. The government did not establish a causal link between the isolated act of oral sex and the threat of physical violence. Any physical violence that occurred during that episode in January 2010 preceded Geronda providing oral sex to the defendant. Geronda's testimony simply does not lead to reasonable inference that she gave defendant oral sex because she feared physical violence. Wow, they getting up in their guts, boy.
Yeah.
All right, well, Angie, let's give us a final closing, and then we gonna
Oh,
get out of
okay.
here.
Well, thanks again, Skyye, for hosting us. Thanks everybody in the chat. And
YT.
the saga continues, honey. And thanks for all the panelists and everybody.
Yeah. So, what time you about to go live now, or you going live?
Oh no, honey, I'm about to go to sleep, and I'm gonna let everybody else fight this, that, and the third, and maybe wake
Okay.
up and pick up some more reading on it, and then break it down a little bit more.
Okay, Andrew. Well, thanks for coming.
Right.
I'm trying to come over there and hop on the channel when you go live tomorrow. Then, but thank you for coming in, and you're always appreciated.
All right, thank you.
All right, have a good day.
Bye-bye.
All right, you guys, we about to get up out of here. Thank all the subscribers, all the repeat subscribers, all the new subscribers, all the mods. Thank you for moderating. Thank you for Angie, Courtney Love, Chatham, anybody who came on the panel. I appreciate you guys. We're gonna get out of here. This was an interesting day. Like, shout out to Bonjean. Bonjean. I want to say Bonjean. I think it sounds like it's French. Bonjean. That's why I say that like that. But shout out to her for making great motions for Kales, you guys. Today I first read the motion for a retrial. And then second, I kind of went into the motion for acquittal. Now it is like 60 some pages, so I didn't get an opportunity to read all of it because we'd be here too long. We're already hitting 4 hours, and thank you guys for hanging in there with me and staying here. You are appreciated. I will try to read the rest of this stuff. I don't know. I kind of want to read it online, but it's very long, so I don't know if it has to be broken up in multiple ways, or either I might try and upload it for you guys. I don't know, but we will be discussing it because you guys, excuse me, this is going to be discussed for the next couple of months. Okay, so we might as well be ready and prepared for the argument. Okay. Thank you for the legal Smigals. That would be Angie, Elvira, and Queen Diva for giving you guys input. Is much appreciated. YT, hey, thanks for coming in. Everybody, please hit the like button on your way out. Whenever you hit the like button, it does share my information on YouTube. Also hit the subscribe button. We are getting our subscriptions up. We got more people coming to the channel. Thank you for that too. Hit the bell next to the subscribe button. That way it'll give you notifications. If you're not getting notifications when I go live, just unsubscribe and resubscribe and hit the bell. And that should bring you all back into the into the notification rotation. As always, guys, free Kales. Do everything in God's divine order in order to make sure righteousness prevails. Okay, she said 10 pages a day. Thank you guys for modding. I really appreciate that. That's important to me to welcome people and, tell people goodbye, because, some people are scared to come in and, I just want them to know we not gonna bite them yet until they get out of line. But there's another motion she filed as well. A total of, wait a minute, what? Now, are you talking about the little short one, Elvira? You saying 3 motions? Because I got, they need to send me a short one. Let me see. Hold on a second. Look, y'all, here we go. Give me 1 second. He sent me a short one, so I'm not really sure if I got that, but I will be looking out for it. And thank you. But all right, you guys, I'm gonna try my best to come back tomorrow. I do have a lot on my plate, but if not, I'm gonna try and peek on somebody's channel, and we definitely gonna get it in. If not Saturday, then Sunday. Y'all be ready, okay? And I might try and upload it. You know how I did the other one slowly, so everybody could read on their own. I might try and do something like that. But let me see. She said where she explaining how she didn't get to meet with Kelly to finish the one she turned in. So we have to see what's going to happen with that. Oh, okay. 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 So basically, it might have been more, to these motions than what was already submitted. Interesting. Thank you for sharing that. All right, you guys, we're going to get out of here. I'm sorry I did my ending too early, but as always, do everything in God's divine order. Do everything in the spirit of righteousness to make sure righteousness prevails. All right, you guys, take care. Skyye Lyfe loves you guys. Good night.